Good morning. Welcome to oral argument. Before I have the clerk call the calendar, we'd like to welcome 12 students from USC's senior level, their class on advanced legal writing. They're here with their professor, Antonio Coronel Elefano. Can you give a wave and thank you for being here, bringing your class to watch oral argument. Thank you. Jorge, the clerk may call the calendar.
Good morning. The Supreme Court of California hearing oral arguments in San Francisco on Monday, October 2nd, 2017 at 9 a.m. Case number is 233898, T.H., a minor, etc., et al., Plaintiffs and Appellants versus Novartis Pharmaceuticals Corporation, defendant and respondent. For respondent, Mr. Eric G. Lasker.
Ready. For
appellants, Ms. Leslie A. Bruckner. And Mr. Benjamin L. Simenu. Case number is 234617, Badrudin, plaintiff and appellant, Badrudin Kurwa, plaintiff and appellant versus Mark B. Kisslinger et al., defendants and respondents. For appellant, Mr. Robert S. Kirstein.
Ready, Your Honor.
And for respondents, Mr. Dale B. Golfar.
Ready, Your Honor.
And case number is 235549, Patrick Lowell Jackson, petitioner, versus Superior Court of Riverside County, respondent, the people as real party interest. For petitioner, Ms. Laura Arnold. And for real party interest, Ms. Natalie Love.
Thank you. In the first matter, T.H., a minor, versus Novartis Pharmaceuticals Corporation, we welcome the Honorable Louis R. Morrow, Associate Justice, Court of Appeal, 3rd Appellate District, sitting on assignment. Counsel, you may proceed when ready.
May it please the Court, Eric Lasker on behalf of the petitioner, Novartis Pharmaceuticals Corporation. I'd like to reserve 3 minutes of my time for rebuttal. Your Honors, respondents ask this Court to break with decades of product liability doctrine in which this Court has held that a manufacturer's duty for warning is limited in scope to the consumers of its own products. And the respondents ask this Court instead to adopt and to recognize two brand new duties in the law, both of which are necessary for their claims to proceed. First, they argue that a former manufacturer should owe a duty of care to individuals exposed to a subsequent manufacturer's product. And second, they argue that a brand manufacturer should owe a duty of care to consumers of its competitors' copycat generic products.
Was the product changed after you sold it?
No, Your Honor, it's a brand product, and it is the same product, but under the federal...
changed after you sold it?
I'm sorry, Your Honor?
Was the label warning changed after you sold it?
It was not, Your Honor, and that points to one of the perverse effects that would occur if this Court were to recognize the first duty of care for a former manufacturer, because that duty would create an incentive under state tort law for a subsequent manufacturer to freeze that label in place, because under the respondent's theory of the case, if the label is changed, then the subsequent manufacturer can no longer point back to the former manufacturer and trying to offlay some of their liabilities.
So I want to ask you about that because it's not at all obvious to me, and I want you to help me understand why it's your argument to the contrary, that a subsequent manufacturer wouldn't update the label if information became available indicating that the drug had other contraindications and effects. But before I ask you about that, let me just go back one step. You said its own product, and I gather you would want us to draw a distinction based on whether the company, let's say a brand name drug manufacturer, is at that point manufacturing the drug or not. Is that correct?
Yes, Your Honor, and that is the standard that has been set forth as this Court recognized in O'Neill over decades of product liability.
So your position is that O'Neill controls this, and the way you read O'Neill is that O'Neill set a bright line rule. Here's my question then, particularly given that you mentioned O'Neill. Why isn't it enough for you to win this case to say, look, you know, the way California tort law works, particularly with the question of whether we should make an exception to the general existence of a duty and say that there's no duty, is we apply the Rowland factors. Now, of course, that's what happened in O'Neill. O'Neill applied the Rowland factors. Why isn't it enough for you to say you should apply the Rowland factors here and the balance of all the competing concerns just works in our favor that there shouldn't be a duty? Or is that what you're saying?
Well, Your Honor, we do believe for each of the separate duties, and I'll get into that in a moment, that the role and factors do weigh very heavily against the recognition of each of the two duties that the respondents are asking for here. But Your Honor mentioned the issue of an exception, and that, of course, is based upon Civil Code 1714. The language of Civil Code 1714 expressly refers to conduct taken by a party in the management of its own property or persons. And this court's jurisprudence in applying 1714, if you look at Cabral, if you look at Preston v. Goldman, which is a former landowner duty argument, or if you look at Kisslinger, where the court looked at control over its manufacturing process or its control over its premises, in each of those cases, the 1714 underlying duty is premised on that nature of control.
Hey, but counsel, if I could, just if that's your interpretation of 1714 and O'Neill, it leads me to the following question, which is, it's just a small tweak on the facts here. It's not the facts here, but suppose for a moment that a brand name manufacturer had an authorized generic that they authorized, right? So in some such arrangements, it would not be beyond the realm of possibility that the brand name manufacturer would be getting revenues from the authorized generic, from the sale of the authorized generic. In a situation like that, supposing that the brand name manufacturer was no longer manufacturing the drug, but it was at that moment getting revenues from a product that bore the precise label that the brand name manufacturer arranged for approval from the FDA from, then your rule, I think, you tell me if I'm wrong, would be that there's no duty there.
If the individual is injured used the generic drug that manufacturer was manufacturing, then there would be a duty because it is their product. And recall—
An authorized generic. So the individual is using the authorized generic, but at a time when the manufacturer is getting revenues back from the sale of that. Does that not change the analysis at all? That there's financial benefit at that very moment for the brand name manufacturer, even if the brand name manufacturer is not actually manufacturing the drug at that point?
Well, I guess I'm not understanding. If the brand manufacturer has its own generic product and is manufacturing that product and that causes injury, then there is a duty there. Now, there may be an issue of preemption, which is a separate question in the law, but there are, throughout the law, numerous instances in which there is a party that has an immunity or a protection. In O'Neill, for example, the United States Navy had sovereign immunity. And even though the U.S. Navy specified, required asbestos on that ship and had knowledge of the dangers of asbestos, this court, in its role in factors, didn't say because another party has immunity, that therefore adds a duty of care to a third party, a new duty of care.
Could I ask you, counsel, so you mentioned the issue of control. As I understand it, the lawsuit here is only about the period during which the brand manufacturer did have control of the label.
Yes, Your Honor, and at that point in time, the brand manufacturer had the exact same duty of care that every other manufacturer has in the economy under state tort law. It had a duty of care that was owed to the consumers of its product. And this is a duty that this court has recognized creates the proper balance of incentives between product availability and product risks.
The label has some downstream consequences, right? I just want to fix for the moment that there is no liability being premised on anything out of Novartis's control. The liability is premised on the label within Novartis's control during the time Novartis was selling the product.
I don't agree, Your Honor, because once Novartis transferred the NDA to a subsequent NDA holder, that NDA holder now had complete control over whether or not Novartis would have any duty that continues. The only way they can
Can I ask a clarification on that?
Sure.
Answering this question. Didn't even though Novartis transferred the NDA, I understand under the federal regulations that the warning label and changes to the warning label were restricted by federal regulations such that only the brand manufacturer could make the changes?
Well, Your Honor, I guess
Eric.
there's 2 points in that. And again, there's 2 separate duties here that the respondents are seeking this court to adopt. One is the former manufacturer duty. Once that NDA transfers to a new NDA holder, immediately under federal law, the new NDA holder has complete control over that label. And that's the way that the law should be. You want to have an NDA holder that has current control and utmost total authority over that warning. And it is not the case, and I know respondents argue this, but it is simply false to say that the subsequent manufacturer is now bound by the warning from the former manufacturer. That would be a horrible policy to have in place, and it's not the policy.
But really, let's just think about how that plays out day by day, okay? So I gather the core of your argument is, let's say that 10 years have gone by. It certainly is not, in your estimation, it's not accurate to say that the subsequent manufacturer doesn't have a great deal of latitude. In fact, the responsibility, as it were, to maintain the label once the NDA has been transferred. But I want to talk about, let's say, a week, 6 months after this transfer has happened. Because I gather your argument, again, I'm going back to the manufacturer and not manufacturer distinction I gather you're trying to get us to adopt. Your argument is the moment the NDA is transferred, even if realistically, as a matter of practicality, it's unlikely that the new holder of the NDA hasn't really had the chance to sort of figure out whether any change in the label has been made, the moment the NDA is transferred, that cuts off the duty. Is that right?
That's correct, Your Honor, and it is exactly the point that federal law makes sure is the case. When a company purchases an NDA, it doesn't do it blind. It has due diligence. It has to know from day one what the labeling should be for that product. And when it purchases the NDA, it needs to tell the FDA,
but
this is what the labeling is going to be.
So why doesn't federal law cut in exactly the opposite direction? Because I gather your point here is federal law does, once the NDA is transferred, provide the responsibility of the NDA holder to update that label to make it at least as strong. But doesn't it also require the use of the label being at least as strong unless it is updated? So in other words, in that interim period, while the new NDA sort of figures out and gets its head above water whether that's the right label or not, they're under a responsibility, are they not, to keep that label?
Your Honor, I would submit actually to the contrary. The federal scheme is set up so that the new NDA holder cannot wait. You don't want to have a system where there's this gray period where new NDA holders can sort of catch up. They need to have that knowledge and that responsibility from day one, because otherwise you're creating a gap.
Do they have the practical ability to change the label from day one?
Yes, from day one, in fact, when they take over the NDA, they tell the FDA what labeling they're going to be using, and they should have gathered the information through due diligence to be able to do that from day one. And they have this issue about a ratchet or about whether or not they can weaken or strengthen the label.
What was the date of the transfer?
2001. It was 6 years prior to the date in which the alleged drug use occurred in this case.
What was the state of the science as of that date?
Well, Your Honor, there'll be a dispute of that if there was a duty of care in this case. That goes to the issue of breach, it goes to the issue of causation. But it doesn't go to the existence of the bright line rule of whether or not a duty exists. And again, keep in mind, the brand manufacturer...
Well, just humor me. What was the state of the science?
The allegations with respect to the state of the science was that the science was changing over time, and the complaint alleges studies before the transaction and studies after the transaction. And in fact, the one study that they point to with respect to autism was, I think, 4 years after the transfer took place. But again, that's talking about the specific facts at issue in one case. And this court's role in setting a duty is to set clear lines of conduct, categorical rules going forward.
In your brief, you cite the Vermont District Court's decision in a case called Lyman versus Pfizer, which assumed for the sake of argument that there was a duty in somewhat comparable circumstances, although I think in that case it was more like 2 years between the transfer of the NDA and the alleged harm. But said that under the circumstances where 2 years had elapsed, there could be no causation as a matter of law because the successor manufacturer's duty to update the label in light of new evidence of potential hazards superseded any role that the original manufacturer might have played in the contents of that label. Are you making a comparable argument here, or are you focusing solely on that first step in the analysis, solely on the duty of care analysis?
Well, Your Honor, certainly on a causation analysis, this court could reach the same conclusion. But I think the key point here is it's not only Lyman. Every court that has considered this issue of whether a former manufacturer owes a duty of care to consumers of a subsequent manufacturer's product has said no. That's in California and it's across the country. There's no court that has adopted that. And again, it goes...
Just to be clear, so you would also make the argument in the alternative that even if there is a duty of care, that there could be no causation as a matter of law when a significant period of time has elapsed between the transfer of the NDA and the harm alleged.
We certainly agree with that, Your Honor, but in the first instance, again, with a former manufacturer duty, there should be no duty in the first instance. And if you go through all of the factors for a former manufacturer duty, under the Rowland test, the issue of foreseeability in this case relies on the argument that a former manufacturer should anticipate and foresee that a new NDA holder will violate federal law. That is the basis for the foreseeability argument.
That's true in a sense, and I think you're right, of course, that the authorities point the other way in general. The general rule is that once you have a successor manufacturer, the liability is cut off. But we're talking, I think, about a very specific regulated regime here. And I guess I want to ask you about the basic point about what a new NDA holder's obligations are. Does the regime really contemplate the idea that once the NDA is sold, that the new entity, the new holder, starts from scratch in reviewing all the research up to that point, in covering all the same ground that the prior NDA holder did? Is that the extent of the duty? Is that every time something changes hands, it just starts back on square one?
No, Your Honor. What the federal obligations require is that before a company buys an NDA, it inform itself of all the potential risks and potential issues with that drug. Because keep in mind, it's not only that the exclusive authority for the labeling transfers to the new NDA holder, but the former NDA holder is forbidden, as a matter of federal law, from making any changes to the label or making any statements about the safety of that product.
But if the duty is limited to the time of ownership, then why doesn't the requirement to prove breach of duty and causation adequately protect innovators?
Because, Your Honor, again, that's separation of causation and the facts of an individual case, and the plaintiffs can allege whatever facts they were. But the duty of care here that you're imposing now is different than the duty that tort law has held for every other manufacturer in society creates the proper balance. Because, again, brand manufacturers have a duty of care to consumers of their own product. And that duty of care is one that the tort law has held, creates that proper balance between product availability and product innovation.
That's why I asked a question
risks.
about what can realistically be expected, in a way, of the new NDA holder. Because you're right, this is about balance. It's not. I don't think this is about bright line rules. That's sort of the initial point, is that we're trying to draw a balance of what the right incentives are. You could be. I suppose you could have a different regime in which, I think this is a regime you suggest, which is that if there was fraud or if there was some sort of negligence in the representation of Novartis to AI Pharma, then the successor company can always sue in fraud or negligence against the seller, right? But the question is whether that's adequate, right? That's possible, but is that adequate? And so why wouldn't tort recognize within reasonable boundaries, and by reasonable boundaries I mean elements of breach, especially causation, right? Within reasonable boundaries, the idea that the original seller of the drug was in the better position, in this instance, to ensure the safety of the drug based on the existing knowledge it had at the time. And knowing that its label is going to carry forward to the successor entity, even if the successor entity has its independent obligation, which, by the way, mitigates against your hypothetical that the successor isn't going to do anything. They are going to do something. They're going to be liable too, right? But just as an additional layer of security, because they're in a good position to have monitored the label, they should also have a duty.
Because if that was the rule, Your Honor, then the federal statutes would allow for that possibility. The federal statutes do not allow for a foreign manufacturer to continue to be involved in the labeling from day on day
It's
on
not
day
your
two.
position that federal statutes preempt state tort law on this issue, right? I want to just clarify. I think your position is rather to the extent that we think that it is informative for us to consider the way federal law allocates responsibility to NDA holders. The moment the NDA is transferred, then federal responsibility is transferred, right? You're not making an argument that we're preempted in some way.
It's not a preemption argument, but, Your Honor, it goes to the question of foreseeability. what should a former NDA holder foresee when it transfers the NDA? And the whole federal scheme is set up so that the former manufacturer should foresee that the subsequent NDA holder has obligations from day one.
As a follow-up to Justice Liu's question, depending on the facts, is it possible for both the predecessor and the successor manufacturer to be liable for failure to warn of the drug's potential danger?
Well, Your Honor,
the facts. I realize that I'm not talking about your specific facts, but
we would submit that it is not. And again, the issue there is if you are putting the burden or creating a situation where you could allocate the burden, you have a subsequent manufacturer that is now earning all the profits.
The state of the science as of the transfer date of 2001 was that there are potential dangers to pregnant women taking this drug. And you were manufacturing the drug at that time, and that warning was not on your label.
That is the allegation, Your Honor, and there is a duty of care on the former manufacturer up until the time it sells that duty, under which the tort law creates that proper balance to create for the former manufacturer to update the warnings. But what you're suggesting here, and what respondents are suggesting here, is that a new duty be established on the former manufacturer that would undercut the normal incentives that tort law would apply on that subsequent manufacturer, because now it's no longer the balance for the subsequent manufacturer of each pill, and the subsequent manufacturer decides to enter this market, decides to sell this product with that labeling, and the subsequent manufacturer earns the profits. They're earning the profits, but now they don't have to pay the full cost. And so you're now weakening the incentives, the balance under tort law that exists for every other manufacturer.
Can you tell me succinctly what are the roll-in factors that you think work in your favor to find an exception to a duty here?
Okay, well, again, for foreseeability, we've talked about the issues there. For public health with the former manufacturer, again, we believe that creates a horrible incentive under state tort law for a subsequent manufacturer to sit on the warning and not be as diligent as federal law would require it to be. With respect to the
just to pursue that one, just briefly, I don't want to get you off the other factors, but briefly, you're not arguing that there's some kind of safe harbor for the successor manufacturer if they keep the label the same, right? They could also face liability.
Correct, Your Honor, but under the new duty, their liability would be decreased. They'd have less liability than every other manufacturer in the economy, and so they're earning all the sales, and they have less of the liability. So that's shifting the balance that exists. With respect to...
Well, I'll just say there may be some disagreement about foreseeability and incentives for both the former and the successor. But I'm curious what other roll-in factors do you think in terms of the policy aspect? Because the ultimate point of having the duty responsibility and the rule we have in California, unlike the other jurisdictions, is to protect the public. And now we're in this very regulated area of pharmaceuticals. So foreseeability factors aside, how does the public policy benefit you in this case?
Okay, well, as I stated, and let's start with the former manufacturer, we believe that it is a significant disadvantage to public health, hurts public health, to tell a subsequent manufacturer you don't have to pay your full freight of this, you can shift some of your allocations over, because that's changing the burden that normally applies on manufacturers. Subsequent NDA holders no longer have that burden, so that's bad for public health. With respect to the burdens that are imposed on a former manufacturer, just as this court recognized in O'Neill, the former manufacturer is going to have to try to monitor what's going on with the subsequent manufacturer because its duties, while you say that it maybe the breach may be judged based upon prior to transaction, its obligations, its liabilities are going to be based on what the subsequent manufacturer does, and the former manufacturer has no ability to cure. They've got this burden.
Insurance.
Well, again, for insurance companies don't provide insurance for an unquantifiable risk. What you have here will be a situation where a subsequent manufacturer controls what the liability is going to be for a former manufacturer. The former manufacturer, or the insured in this case, would have no control over this, would not be able to quantify what the risk is, would have no way of mitigating any potential risk. Insurance companies don't provide insurance for that. There's no vehicle to provide insurance where you have no way of quantifying it. That's how insurance works.
Another factor that would cut against insurability, the fact that it's unclear how long liability would extend.
That's exactly right, Your Honor.
Predecessor.
And if we switch over to the roll-in factors on the separate burden, because again, plaintiffs need the court to recognize two burdens in this case. For the Rowland factors with respect to an innovator manufacturer, again, on foreseeability, the foreseeability argument doesn't rely upon any discretionary choice of the brand manufacturer. It relies upon the federal statute and the sameness requirement. But that federal statute also imposes obligations on generic manufacturers to update warnings when they become aware of safety information. And again, the foreseeability argument in this court would be based upon the premise that the generic manufacturer is not abiding by those obligations. But there's also the issue of public health, because again, you're shifting the burdens. After generics come into the market and they take over the market, you now have a situation where the normal balance that would apply to a brand manufacturer, like every other manufacturer in the economy, of balancing the product benefits and the value of the sales versus the risks, is dramatically shifted because the generic manufacturers are earning all the profits. The brand manufacturers are earning none of the profits. In order for them to equalize this and to suppress, if you will, the market for the generics to lower their risk, then they're going to increase the warning labels.
I think I see your argument on that point, counsel. But let me go back to a case that Justice Kruger asked you about. This is Lyman versus Pfizer, the Vermont case. So it does seem to me, I just want to make sure I understand this point, that you are making a somewhat different argument. Presumably, you're embracing the idea that as a matter of law, causation does not work in favor of the plaintiffs here. But I do think, just to underscore, your argument is more premised on the idea that these Rowland factors balance well across the board if we draw the line between duty and no duty around whether the company in question is currently manufacturing the product, right?
Correct, Your Honor.
And just, connect the dots a little bit more between that bright line conclusion across the board and in particular the public health related notion you were addressing on the Rowland factors. So in other words, your position is not, well, this is a situation where 3 years, 4 years, 5 years, 6 years have gone by, so as a matter of law it sort of operates this way, Rowland. It's more like public health will be best served by having a bright line rule such that there are really no exceptions, even if facts might be quite different from what we have here, that would allow us to conclude that a non-manufacturer has a duty.
Your Honor, and I'm running out of time, but if I can answer your question, that is exactly our argument, and it goes back again to the fundamental nature of tort liability and product liability that this court has held for decades, which is that the proper balance between product availability and product warnings is based upon a manufacturer internalizing those costs for the profits it earns versus the risks of the product. And under both of these proposed duties that the respondents are asking for, that burden is shifted. It is a different burden than applies to every other manufacturer in the economy. And the question is, why would one think that that advances public health? If it's contrary to what this court has held is the best rule for public health across the board in every other manufacturing situation, why is it that shifting that burden would improve public health here? We would submit that it's not. And, Your Honors, the respondents acknowledge that their rule cannot apply in strict liability. They acknowledge there can't be a duty in strict liability. Well, that's fatal to their claim because in Webb, this court this last term made very clear that it's a unitary theory of duty. The same duties apply whether it's strict liability, failure to warn, or negligence, failure to warn. So if, as respondents acknowledge, and the case law makes clear, you can't have a strict liability duty in this case, then under Webb and this court's precedents, you also would not be able to have a negligence warning. Thank you, Your Honors.
Thank you, Mr. Lester.
Good morning, and may it please the court. Leslie Bruckner for the plaintiffs. Perhaps the most basic principle of California tort law is the principle that everyone is responsible for injuries caused by their negligent and willful misconduct. And in this case, what we're alleging is that Novartis marketed a drug to pregnant women that it knew was dangerous to the developing fetal brain, without warning of that risk on the drug's label. And it also knew, and this is undisputed because federal law requires it, that the negligent misrepresentations on its label would be repeated on the label of every single generic version of that drug.
I think the most difficult question here concerns the lapse of time between when Novartis was manufacturing the drug and when the plaintiff's mother here consumed the drug, which was a span of approximately 6 years. And I guess the most difficult question for your side, I think, is there any point at which liability would be extinguished, or does a manufacturer in Novartis's position face the prospect of indefinite potential liability?
Your Honor, I was just going to say that our plan had been for my co-counsel to address the former manufacturer liability, but I see we're going to have to throw that plan out the window, which is fine. I think the specter of perpetual liability is overblown. There are a couple of reasons why. First, I think it's very unlikely that in the real world that a manufacturer would be held liable years down the road.
Well, we're 6 years down the road here. So how many years down the road can we say with unbounded confidence that they wouldn't be held liable?
Well, what we're talking about here is a 6-year gap between the date of sale, 2001, and the date that the plaintiff's mother ingested the drug.
Right.
And that, and what Novartis is arguing is that there could be decades that are elapsed, and that is.
Okay, fine. So you say 6 years brings you within the scope of liability. They want to say the sky will fall and it'll be decades. But we're drawing a line here.
That is true, Your Honor.
So you're taking the position that 6 years is not enough to extinguish liability. What do we do? Just pick a number? Hope a jury will pick a number?
I would say, first, that should theoretically be no statute of limitations on fault, and that is a key.
If that's true, then that gets closer to their position, which is decades of liability.
There are, if the court is truly concerned about the elapse of time, there are a few different limiting principles that the court could draw, but I would say, as an initial matter, as we argued in our brief to the court, the specter of perpetual liability is overblown because there are ways that manufacturers could protect themselves from being held liable after they leave the market without first updating their label. First of all, let me say, manufacturers can protect themselves by updating their label before they leave the market. And if they do that, then this whole specter of perpetual liability disappears right from the get-go.
Does have updated AAI Pharma's label here?
No, it could not. Absolutely not. And
could have updated its own label.
It could have. If Novartis had updated its label before the sale, then none of this would have happened.
And is there a financial disincentive for the seller to do that?
There would have been a financial disincentive for Novartis to do that in this case because the very labeling change that was needed would have undermined the principal market value for the drug.
So suppose, counsel, I understand that argument as being something that cuts in favor of finding a duty here, but suppose I'm concerned about the O'Neill case. How do you distinguish the O'Neill case?
So O'Neill, Your Honor, should have no bearing here for several reasons. There are so many reasons to distinguish the O'Neill case, I hardly know where to begin.
Give me the 2 or 3 best ones.
So the principal holding in O'Neill is that, generally speaking, a manufacturer cannot be held liable for injuries caused by another manufacturer's product.
Although O'Neill doesn't say generally, it says it can't. Correct?
Fair enough, Your Honor. That holding was limited to the strict liability claim in the case. As one of the other justices pointed out, the negligence claim in the case was run through the Rowland factors, and that's exactly what we're asking this court to do here. But even the strict liability claim in the case was subject to an express exception for cases where the manufacturer bears, I think the court said, some responsibility for the injuries. And in this case, in a case where a manufacturer of a generic, where a consumer is injured by a mislabeled generic drug, the fault does not just lie somewhat with the brand name manufacturer. It lies exclusively with the brand name manufacturer, and here's why.
The original brand name manufacturer? Because we have two levels of generics here, don't we?
Right now, I'm talking generically, excuse the term, no pun intended.
It's hard enough, this case.
It is, fully agreed, Your Honor. Right now, I'm talking about the broad question of whether or not there should be a categorical exception for all brand name manufacturers for all injuries caused by generic drugs. That's Novartis's home run position.
That's not the circumstance we have here.
That is not the circumstance we have here.
That's right, and it is important that it is not the circumstance we have here. It is clear that the brand name manufacturer has an obligation to label its product that it makes and it sells, and its label is binding on generics. The trouble here is that we have a new brand name manufacturer. And to the extent that we are less than precise about keeping straight that distinction between generics and brand names, we muddy the analysis. That's why I'm kind of a little rigid about this. So that in this case, it is certainly true that we can look to federal law to talk about the obligation that a brand name manufacturer has with regard to its labeling and the degree to which that's binding on generics. But now we're talking about a jump shift to a new brand name manufacturer. And in your judgment, well, let me just ask you this, in your judgment, does that make a difference here?
It shouldn't make a difference here, Your Honor, because there's a causal connection between the negligent label that was written by Novartis, that was left in place when it sold its drug in 2011, and the injuries that were incurred by the plaintiffs in 2007.
Okay, one additional...
2007, yes.
During that intervening period, didn't AA Pharma have both the ability and the responsibility to add warnings to the label?
Absolutely, Your Honor. And this goes to, I think...
How does that figure into the analysis?
I think that this is an answer to one of the Justice's questions. AA Pharma is also, in our view, culpable. A successor manufacturer that does not update its label is also liable. Unquestionably. So our position, to be clear, is that, first, let me clarify something that came up at the beginning of my brother's argument. We are simply alleging that Novartis should be held liable for its failure to update the label prior to the sale of the drug in 2001 to AAR Pharma. We are not alleging that it did anything wrong after that sale. As of that time, Novartis' duty expired.
Why isn't it enough that the consumers who are injured could sue AI Pharma, and then if AI Pharma feels that they were misrepresented, the drug was misrepresented by Novartis, then they could sue Novartis?
Well, because both Novartis and AAR Pharma are culpable, and the fact that there has been an intervening negligent actor does not let Novartis off of the hook.
So can I return you to where we started? Because I'm not sure that I ever fully understood your answer to the question. Is there any point at which you could say, as a matter of law, not without having to submit it to a jury for consideration, that Novartis simply is no longer liable for whatever choices it made with respect to the content of its label in 2001? So 10 years down the line, AA Pharma, in the meantime, has had the sole ability to control the content of this label, to add warnings as new information comes to light about potential hazards of this drug. Is there any point at which you would concede, as a matter of law, that you could no longer proceed against the original manufacturer?
I would say that, as a matter of law, no, but I would say that this court has the ability, certainly, and the authority to draw a line if you're concerned about the specter of perpetual liability, just as this court in Kisslinger limited the duty.
Where is the line drawn? I think that question has been asked.
So let me get back to that question, if I may.
Counsel, aren't there a lot of limits? I mean, in other words, there's summary judgment, right? It's not that all we're concerned about here is the initial question of duty, right? And in a litigated case, based on discovery, which includes the passage of time and facts like that, a court could readily grant summary judgment on the issue of causation in favor of the defendant.
Absolutely.
So there are
Yes, but
lots of limits.
But let me ask you, though, summary judgment is an expensive, time-consuming practice. What we're talking about is the initial hailing into court on a duty. This came to us by way of demur. There's no discovery here yet. So in 2017, if this case survives, you'll be doing discovery back into what was known in 2001 and whether or not Novartis should have known that. Certainly there are going to be civil procedures, but the question really is that threshold question. Do you get them in the door, and do they get past or do plaintiffs get past a demur? So that's no discovery, no cost to the pharmacy, no cost that's passed on to consumers. The question is duty in the first instance as a matter of public policy. And so apart from what we know are some civil opportunities to truncate a lawsuit, the question is, for us, with you saying that we're only concerned about this time frame when Novartis owned the NDA and what they knew then, where does that liability end? I mean, apart from what we know is available in civil procedure.
One way to limit liability is to create an artificial time cutoff. Another way to limit liability is to say that a former manufacturer is only liable and on the unusual circumstance, such as in this case, where the warning that was needed on the drug would have substantially destroyed the market value of the drug. And that's what made it foreseeable to Novartis that AAI Pharma wouldn't update the label. So in an ordinary circumstance, so Novartis has this drug, Brethine, that was aggressively marketed to pregnant women, despite Novartis' knowledge that it was, we believe, damaging to the developing fetal brain. But the bulk of the market value of this drug was for its use as a tocolytic purposes, which is to stop preterm labor. And Novartis had a problem because it didn't want to warn of the risk of the drug because it was going to destroy the market value of the drug. So instead of updating the label, which it knew would destroy the market value, it sold the drug to AAI Pharma. We believe it was foreseeable to Novartis that AAI Pharma would not update the drug, update the label.
Why would it have been foreseeable? Just on a pure profit margin?
Exactly, Your Honor. Because just for the same reason Novartis didn't update the label,
And let me ask you about that.
we believe AAI Pharma.
It's my understanding that Novartis did add a precaution to the label about tocolytic use. Is that correct?
Well, not quite, Your Honor. There was some information on the label added, I believe, in the 1990s that said that the drug was dangerous for the mother. And our contention is that that actually implied a negative pregnant, if you will, that it was not injurious to the fetus. It was not until 2011 when the FDA finally stepped in and ordered that there be a boxed warning on this drug that the label was finally fixed. But to get back to this question, I understand the court's concern about not wanting to have manufacturers on the hook forever, even though I believe that they can protect themselves by having indemnity agreements, they can protect themselves by updating the label. I believe they can protect themselves, but I understand the court's concern. One way to deal with that concern is to write a narrow decision that recognizes the highly unusual facts of this case.
That's why I started with the facts.
Yes.
Weren't the ingredients the same before the sale and after the sale?
Yes.
And weren't the warning labels the same before the sale and after the sale?
Yes.
And don't we have a joint liability here on the part of the predecessor and successor manufacturer?
Absolutely, Your Honor. We absolutely do.
So, counsel, the Lyman v. Pfizer case, the Vermont case that we've been talking about, this is a district court, it's a federal decision.
Yes.
To the extent that you followed that case at all, do you think we should just decide differently here, or do you think there's a way to distinguish that case? I'm
very, very much hoping that my co-counsel has followed that case because I have absolutely no idea what it's about, Your Honor.
Okay, but let me just give you a little more context, right?
Okay.
So zeroing in on this question we've been struggling with about is there a point at which the connection is too attenuated for us to recognize a duty? Is it 2 years, 5 years, 10 years, or is the passage of time not the right variable? You know, in Lyman v. Pfizer, the court says 2 years, too attenuated. And I guess, you know, that raises the question to my mind of whether in the end, as you struggle, which you have a little bit with the question that Justice Kruger is raising and we're all grappling with, you know, do you ultimately land on the position that passage of time really is not such a helpful rubric for figuring out the duty question, but it might be relevant to causation? Or do you think that passage of time might conceivably be an appropriate metric to determine whether it's duty or not, but we haven't reached that point here? And maybe you reach it after 127 years, but you don't reach it after 6 years.
I think it's the former, Your Honor. I think that the passage of time is a factor that a jury could certainly consider in determining whether or not it was reasonably foreseeable to a manufacturer, a former manufacturer, that its label would remain intact for a lengthy period of time and that nobody would ever update it.
That's helpful, counsel, but of course, you know, that's part of the answer, in as much as it could be a question for the jury, would be a question for the jury under causation, breach perhaps as well, but jury trials are expensive. And so I guess my question for you would be, would it also be a factor that a court could consider in drawing the line as a matter of law at some point, either under causation or some other aspect of tort law?
It could be a factor, I believe, Your Honor, in determining as a matter of law, I suppose, whether or not under, for example, one of the Rowland factors, the consequences of the community, would it be problematic to hold former brand name manufacturers liable into perpetuity? I suppose the court could fit it in that way. Again, I think that there are so many reasons why it's just simply not going to be foreseeable to a former brand name company that its inadequate label is going to remain intact and unchanged by subsequent manufacturers for years and years and years.
So
that this is an issue that's going to come out in the wash.
But why, if that's the case, why would it have been foreseeable to Novartis that 6 years down the line? I mean, 6 years is not a short period of time. Why would it be foreseeable that 6 years down the line, the successor manufacturer would keep the label in place without updating it in light of evolving scientific evidence?
Well, that brings me back to the singular fact about this case that makes this case so extraordinary, which is that in this case, the exact warning that was needed on this drug, that this drug is dangerous, that pregnant women should not take it because it will damage the developing fetal brain. If that warning had been on this label, it would have wiped out 50% of the drug's market value. And that's, I would venture, a very uncommon scenario. I don't think that there are very many warnings that would actually destroy the principal market for the drug. This is a drug that
Why wasn't it the successor manufacturer's job to figure that out and act accordingly?
It certainly was the successor manufacturer's job to figure that out, but it was also Novartis's job to figure that out.
So Novartis can be sued by the successor manufacturer.
That's a good question. I don't know the answer to that.
That's the whole case. I mean, the whole idea here is that the chain of liability ends, right, when the sale occurs. And so if there's a claim against Novartis, it's to be brought by the buyer, not by the consumer.
Let me answer it this way. I don't think, actually, that the subsequent manufacturer could sue Novartis because the subsequent manufacturer has a duty to conduct its own due diligence. And in fact, in this case, we've never alleged that AAR Pharma was duped into buying this drug. We think that AAR Pharma knew exactly what it was getting when it was bought this drug.
Suppose, counsel, you know, to follow up for just a moment on Justice Liu's question, be more specific about it. So suppose that, I mean, AAR Pharma here is bankrupt, but leave that aside. Suppose that AAR Pharma does sue Novartis. Does that or does that not affect the duty that Novartis has to the users of a generic drug downstream after it's transferred the NDA?
So, I'm sorry, Your Honor, I missed the beginning part of your question.
So even if AAR Pharma could sue Novartis,
yes,
how does that factor into the duty analysis between Novartis and the downstream consumers of the generic drug?
I don't think it should matter because Novartis still breached a duty of care to the consumers of its drugs. I mean, at bottom, that's what this case is all about. You take away all the bells and whistles, all the doctrine. Novartis breached a duty of care when it put a warning label on its drug that was inaccurate and negligently misrepresented the injuries. And if I may, Your Honor, I would like to hand the rest of this off to my co-counsel because I see my time has expired.
Hand off the baton.
Beg your pardon?
Just before you hand off the baton.
Yes.
It seems to me there's a disconnect. You are saying, and let's just assume for purposes of this question, that Novartis did indeed know or reasonably should have known that the danger to the fetal brain was a known risk. They didn't make the drug that caused this injury. This drug wasn't purchased from them. This child was not injured by a drug they marketed. Doesn't that create a disconnect, particularly after 6 years?
Absolutely not, Your Honor, because the problem was never with the drug. The problem was with the warning, and the warning was written by Novartis.
If I do something bad and somebody is injured downstream, not caused by anything I did, I'm still on the hook.
Well, in that scenario, you would not be on the hook, but in this case, the plaintiff's injuries were directly caused by what Novartis did, and that's the distinction. And the reason they were caused by what Novartis did is because Novartis designed the drug, wrote the label, and it knew that its failure to change its label, it was reasonably foreseeable to Novartis that that would injure the plaintiffs, and that's what happened in this case. Thank you.
Thank you, Ms. Bruckner. Mr. Simonu, you'll have 8 minutes.
May it please the court. I want to jump right into this question of perpetual liability because I can see that that's obviously a concern to this court. And the one thing that is being left out of this discussion is we're talking about sophisticated entities here. We're talking about major multinational pharmaceutical corporations that have the ability to limit their liability through contractual means. And I'm speaking specifically here about the concept of an indemnity agreement. Every time a brand name manufacturer sells an NDA to a successor manufacturer, in the wake of a decision from this court affirming the decision below, I can almost guarantee that these brand name manufacturers would respond to that by inserting a provision in those sales agreements that require the successor to indemnify them for any subsequent actions involving allegations of a negligent misrepresentation or negligent failure to warn.
Of course, that only works if the other company is still solvent.
That's correct,
which
Your Honor.
is the whole unspoken elephant in the room here. So the people who made the drug, who 6 years after their purchase failed to label the drug accurately, if we assume that your facts are correct, and I'm happy to do that for purposes of this, they're out of business now. So the drill here is to find somebody else who might be liable who can be the deep pocket.
Respectfully, Your Honor, that's not what is animating why we're here today. Regardless of AAI Pharma solvency.
It seems to run counter to your, not to worry, because they could take care of it by an indemnity agreement.
I mean, if the point is, will there be some subsequent successor manufacturers who are insolvent and that therefore defeats the purpose of the indemnity agreement, I suppose that.
And if that's true, then are we back to unlimited perpetual liability?
Well, the answer is yes. I mean, if the question is, can we ever scrub this possibility of perpetual liability out of this equation, admittedly, the answer is no. I wish that weren't the case. I wish I could stand up here and say, it's right at 10 and a half years.
Congratulations to you for being so straightforward.
Yeah, well, Your Honor, I'm happy to do that. And let me say that because really that question is asking this court to create a judicial statute of repose. And I don't think that's how this system is designed to work.
Well, your co-counsel said that perhaps that would be one way to deal with this, is to create and I think she used the word arbitrary, an arbitrary statute of repose. And I deduce that you would not necessarily be in favor of such a solution.
I would not be in favor of a solution. I think counsel's comment may have been a nod to the awesome power of this court to basically limit liability if it wants to. And I know in Kessner, the question was, are we going to confine this liability with these asbestos fibers somehow, some way? And the court, I don't want to say artificially, but the court, I think, reasonably said we're going to limit it to people within the family of the employees. And I think that was a sensible compromise. Here, there's something different about time, I think, that makes this a tricky proposition. And again, I don't think that's how this system is supposed to work. I think the threshold question comes to this court to say, is there a duty as a theoretical matter, as a broad statement? In some cases, there can be liability. I think that's this court's job in the primary instance. And the answer here is yes. Nodding, as we must, to the possibility that this could stretch far into the future, maybe further than it would make us comfortable, admittedly.
And that a finder of fact in the future may say, oh no, this is too much, we're not going that far.
Well, that's exactly it, Your Honor, because there's both a macro and a micro approach to solution to that on the back end. The micro approach is the one you just suggested, which is we're not talking about liability. We're talking about a duty of care, and it's going to be for the juries to decide whether or not this delay made it foreseeable to Novartis, or whether there was really a causal connection here. Those issues are still going to go.
One concern that I've heard expressed is that down the line, a jury might inappropriately be so sympathetic to a victim that they deviate from the requirements of finding breach of duty causation. How can you reassure us about that? Are the protections in place already?
The answer is I cannot reassure you of that possibility, Your Honor, but I'm glad you asked that because I think that kind of shows the folly of this line of thinking. What we've done just now is we've stacked yet another hypothetical rare possibility on top of an additionally hypothetical rare possibility. We're talking about...
It's a rare possibility that a jury might be sympathetic to a very sympathetic victim suing a great big manufacturer. That doesn't seem all that rare.
I don't think the possibility of jury sympathy is unrealistic, but I think respectfully the possibility of jury sympathy leading them to abrogate their duties, at least speaking from a...
Oh, yeah, because that never happens.
Speaking from a trial lawyer's standpoint, Your Honor, I wish it were as simple as bringing an injured party into the courtroom.
So let's say we have, to take the extreme case, we have a case brought 20 years after the transfer of the NDA, and the case, under your theory, has to go to a jury, right, for consideration of whether or not both manufacturers breached the duty and caused the injury. How does a reasonable jury, in your view, how does it think through the question of causation and apportioning responsibility between these two manufacturers when you have a significant amount of time that's lapsed? What is the right set of questions to be asked?
Well, I think, this is all sort of artificial, but in that scenario, I would anticipate that maybe the scientific information may have significantly increased so that at some point it doesn't become foreseeable that the successor manufacturer would continue to ignore that drumbeat as a hypothetical. But I think that really it comes down to jury apportionment is really the name of the game that Your Honor identified.
Counsel, if there were no dispute about the 20 years and there were no other facts that really pointed to the original manufacturer's continuing liability in the face of intervening changes in the science or in the marketing of the drug by the new manufacturer, why would that question even reach a jury? I'm a little puzzled why we keep talking about juries here. We have other gatekeeping devices in the legal system to screen out claims. Well, and yes, summary judgment is expensive, but it is certainly cheaper than a trial. That's the original purpose of summary judgment, was to save everyone the trouble. And so it seems to me that these questions about length of time would evolve just like the law evolves. Claims of 15 years get brought into court, they're thrown out. Claims of 20 years, thrown out. A body of case law evolves, and then litigants rely on that body of case law to establish legal norms around these claims. Isn't that the orderly development of the law?
That is the orderly development of the law, Your Honor. Absolutely. I agree with that. And I'll say two additional...
Is there any set of circumstances under which you'd be willing to agree with Justice Liu that a certain amount of time would mean that, as you know, whether it be on summary judgment or on demur, that the case simply cannot proceed to a jury at that point?
I can't. Again, I wish I could. I'm just simply not sure that we can snatch a period out of the air. I would say, though, and this is the macro point that I wanted to get to, which is that the other piece that's not being discussed here is the possibility that it's really the legislature's job to impose a statute of repose. And I'll note here as an example, I mean, the law of construction defect, had these very long tails that when a house was found to be defectively constructed. And the legislature, as I understand it, relatively recently addressed that and said, again, arbitrarily, we're going to put a 10-year statute of repose on these claims. I feel like it's the legislature's job to do these sort of artificial time limitations, that it's just going to pick a bright line rule. That's not necessarily the purpose of this court, particularly, I think, in the context of the Rowland analysis, because what we're doing here, and this gets to the point that I was going to address about this idea of a jury, we're talking about a bright line rule that categorically immunizes all former brand name manufacturers because of the possibility that a brand name manufacturer who signs an indemnity agreement finds themselves facing a successor who's insolvent, and then they don't get the case thrown out on summary judgment. They find themselves in front of a particularly, I guess, susceptible jury. I mean,
wouldn't the facts matter a lot in the relationship? So to go back to Justice Corrigan's initial question, I think one of the things we have to recognize here is that the fact that AAI Pharma is bankrupt may not be so atypical of the nature of this industry, right? Some entities are looking to make a profit, but they're falling down on their duty to actually protect the public. Wouldn't it matter in the facts of a particular case whether or not Novartis was aware of who they were selling the product to? And if you really had sophisticated buyers on both sides, if Novartis sold to Pfizer, that would be a very different case, right? We could say, okay, well, there's some confidence there that Pfizer is a company that could undertake the research, do its due diligence, monitor, the label, et cetera, et cetera. Selling to AI Pharma may be a very different proposition. And so we keep the door open on duty because we have to look at these factual scenarios. And some of these are going to be meritorious. Some of them absolutely are not going to be. But we just don't know in advance.
Absolutely right.
So, Mr. Simonu, you may answer the question, but then your time's expired.
Thank you, Your Honor. That's absolutely right, Your Honor. Yes, the due diligence goes both ways. And there's a reason why AAI Pharma is bankrupt. And those reasons, I think, are reasons that Novartis could have perhaps done some diligence to figure out who exactly it is that it's contracting with. That's an excellent point.
Thank
So
you.
what are they?
Go ahead. You may ask. You may finish one more question.
Do I get one more?
You do.
So what are they supposed to do? Say, here you are, you're a reputable going concern, you're willing to pay our price, but we think you're too much of a risk, so we won't sell to you?
That's a possibility. I mean, at least I'm not suggesting that it doesn't have the right to go through that transaction, but it certainly doesn't have the right to go through with that transaction and then get up in court and say, gee, let us off the hook because the successor to whom we sold the drug went insolvent. It's what's good for the goose is good for the gander. It can't have it both ways.
Okay. Thank you. So, Mr. Lasker, everyone's gone over their time. Feel free.
Thank you, Your Honor. Let me first start by going back to the very function of duty and the function of this court in establishing a duty, because it is exactly the role of duty to delimit even foreseeable injury, because this court sets standards and set guidelines going forward. And I think one thing that was clear in the respondent's argument is that they can't come up with any limitation for the burden, for the duty that they would have this court recognize on former manufacturers. And every attempt they have to try and come up with some limitation fails. Now, in the latest argument, Respondent's counsel said there could be an indemnification agreement, and as the courts recognize, that doesn't help with respect to a subsequent manufacturer that goes bankrupt. But it also is a very odd argument to make, that this court should recognize a duty because, don't worry about it, the parties can contract around it, and therefore you won't have the adverse consequences down the line. That's not how duties generally work. And the issue also, Your Honor, about what a manufacturer could do before it sells the NDA. I can tell you that if Novartis had changed the label on the day before it sold the NDA, then the allegation would be they didn't do enough. They knew there was a risk and they changed the label, but not enough. There's no limitation there. Then it becomes an issue of breach. It becomes an issue that goes through full discovery. It's an issue that goes through trial. And the very purpose of imposing a duty or setting a duty of care has been defeated. So, Your Honor, the issue, again, circles back to where we began. Tort law and this court's product liability doctrine over decades has stated that the proper balance to ensure the societal good is for manufacturers, and in this case pharmaceutical manufacturers, in every drug they sell to factor in not only the profits they're receiving, but the potential impacts that that could have on public health. And that creates the proper balance. And what's being argued in this case is to shift that balance, to change that balance uniquely for pharmaceutical manufacturers so that you don't have that same balance that applies everywhere else. And that you create a scenario now where subsequent manufacturers can discount the potential impacts of their voluntary decision. A subsequent manufacturer, a subsequent company that buys an NDA, purchases an NDA knowing about the drug risks, knowing about the label, and making a conscious decision to try and profit off of the sale of that drug. If there is moral blame, it is in the subsequent manufacturer's decision to say, we're going to market this drug even though we know that it has risks and we're not going to change the label. And what this court will be saying is, we're going to give you a discount. Every other manufacturer would be fully liable for that, would have to factor that decision in. But for you, subsequent pharmaceutical manufacturer, despite the fact you actually have greater burdens under federal law, we're going to give you a discount. And that creates adverse public health consequences. It's the very reason.
Have there been consequences that you can point to following the Conti decision?
Well, first of all, Your Honor, let's separate the issues here. Former manufacturer duty has not been recognized anywhere in any opinion across the country. So there is no precedent upon which to look at the impacts of a former manufacturer duty, and that's the impacts that we've been talking about here. With respect to Conti, I would submit that there have been over 100 cases around the country that have rejected that. And for plaintiffs in this state...
I asked, have there been consequences in the marketplace?
Right. Well, to the extent that tort law is supposed to impact on conduct, yes, there has been impacts. It's the very nature of tort law. To say there have been no impacts would mean to say that tort law has no consequences on the behavior of manufacturers. And again, here...
I think Counsel Justice Moore was asking you a slightly different question. I gather the question is, the marketplace writ large, how has it responded, and particularly how has it responded adversely? What examples might there be, or what impact financially has there been, that kind of thing?
Well, as far as identifying specific examples you can trace back to the Conti decision alone, I'm not going to be able to cite you to that. What I can say is that the purpose of establishing a duty here is to change behavior. And for a brand manufacturer now, the situation under innovator liability is you're going to have new entry into that market. You're going to have generics who are going to take over the market. Every product they sell is going to increase your liability. You're not going to make any money off of that, but when they sell their product, your liabilities are going to increase. And your only ability now to protect this, as your market share diminishes, you have two options. You can either overwarn to try and diminish the market share of the generic manufacturer. You're not making money on that product, so bring their market down. That's your competitor anyway, to save on the costs to you, or you exit the marketplace. That is the incentives that are being created here. And the argument that, well, maybe those incentives wouldn't occur is an argument that tort law duties have no consequence. But in both of these cases, both of the duties that this court would need to adopt to allow the respondent's claim to proceed, you are shifting that balance, the balance that's been set over decades of product liability law, the balance that the respondents recognize would preclude any claim under strict liability, and they argue somehow the rule should be different for negligence, and this court in Webb made clear that it should not. So the court has to recognize the departure that is being asked, because it is a dramatic departure from the decades of product liability law that this court has.
Would it matter to you at all whether or not Novartis knew who it was dealing with on the other side, AAI Pharma? Knew of any weaknesses in AAI Pharma, knew of AAI Pharma's capacity to discharge its duties under the law? Does that matter?
Again, now would be an issue of a breach of contract maybe, or a claim between the contracting parties. But here, again, AAI Pharma, talk about the passage of time. It's not like AAI Pharma went bankrupt the next year. And you're now creating a situation where, frankly, a plaintiff is basically has a roadmap. This is how you craft your complaint. Allege this fact, allege this fact, allege this fact, and you can get past demur, and you can try and get past summary judgment, impose all those costs on the former manufacturer.
No, I mean, but my question is, if Novartis knew that AI Pharma, I'm not saying this is actually this case, but if a original manufacturer knew that a successor manufacturer was not in a good position to monitor the label and update the label, is that a relevant fact?
Your Honor, I would state that it is not for purposes of this duty because
there should be no duty even in that instance.
Well, I actually have to think. I have to think about what the
manufacturer can get rid of its product by selling it off to a disreputable successor organization that it knows doesn't have the capacity to monitor the drug. It is sitting on a mountain of possible liability, and it can dump that liability essentially onto an entity that is not sophisticated or possibly on the verge of insolvency with no liability to itself.
Well, Your Honor, there's a question as to whether or not that transaction would go through, because the new NDA holder, of course, has to be approved by the FDA to take on that drug. So that scenario is assuming, again, that the federal regulatory scheme falls down. And I also, again, it's not the facts of this case. AI Pharma was an ongoing operation for years. But to have a situation where you are defining a duty based upon the extremes, again, does not comport with the rule of this court to establish a duty for the general case, for what you would generally expect to be the case. And the more this court tries to carve out, well, maybe there could be this fact pattern, maybe this could be this fact pattern, again, all you're doing is stating to plaintiff's counsel, these are the allegations you need to keep in your complaint.
Could you then illuminate, I know you're over time, but could you illuminate then what is the general case in this industry? What is the general case in terms of the sales of NDAs?
The general case would be, and it's exactly what happened in this case, there's a period of exclusivity. The exclusivity runs out. And then there's a question as to whether or not the brand manufacturer is going to stay in that market or somebody else wants to come in. This happens fairly frequently. And the fact that NDAs, if there's transactions of NDAs and the ability to transact for an NDA, allows that NDA to be put into the hands of a new pharmaceutical company that can invest the time and effort to develop that market. And you want to be able to have that flexibility for NDAs to transfer from one company to another, as opposed to creating a scenario where a drug company says we can't sell the NDA because then we lose all control over the label. We have to hold on to this in perpetuity.
Could you just illuminate then, just from a business perspective, since you're deeper in this case, what are the scenarios typically, right? You're right, we should not make rules based on extreme cases. What is the scenario typically that causes a transaction like this to happen, meaning the original manufacturer decides it's not advantageous to us to stay here, but a successor organization says it is advantageous for us to be here? What is that? If there's money to be made, why isn't the original manufacturer still in that market? That's my question.
Because, Your Honor, there are certain...
All the advantages, by the way, because they developed the drug. They know all about it. They've been investing lots of R&D in the drug. So for them to get out of it, there must be some good reason, and the other entity, must have some good reason to sort of want to get into it too. So why this difference?
It depends on the nature of the particular pharmaceutical company. Once a product goes off of exclusivity, and generic drug manufacturers can come into the market, then they're going to overtake the market. The statistics, both sides agree, in about a year, 90% of the market goes to the generics. Certain brand manufacturers are going to want to take that sale of the NDA to be able to invest in new innovation, new drug products, because that's the focus of their business. There are other drug companies that are not geared towards innovation. So when you have this transaction, this allows for there to be a transfer of funds so that the company that is interested in innovation can funnel that money into new drugs, new therapies that are helpful to public health. And the other pharmaceutical companies that are not focused on innovation can then proceed with the brand drug and try and make whatever future profits they believe they can, because that's not the nature of their business.
So Mr. Lesker, I'll have you wrap up in 30 seconds.
Okay. Well, Your Honor, again, I think it's important for this court to recognize the break from its precedent that this case would require for them to recognize both of the duties in this case. You'd have to establish duties that now shift the balance that this court has held over decades creates the proper balance between incentives for proper labeling and proper product risks. You'd have to now all of a sudden decide that there is some distinction between strict liability failure to warn and negligent failure to warn, which is exactly what this court held last term in Webb, did not exist because respondents concede there's no strict liability here. So the respondents are asking this court to depart from a variety of different doctrines in which the court has over years established the proper rules. And it's the very purpose of this court in establishing duties to maintain those standards and to limit liability based upon the collective wisdom over the past decades. And we'd ask the court to do that in this case and to remand the case with directions that the case be dismissed. Thank you, Your Honors.
Thank you, Mr. Lasker, Ms. Bruckner, and Mr. Simonu. The matter is submitted.
Thank you.
Calling the matter of Kurwa versus Kisslinger, we welcome the Honorable Judith D. McConnell, the Administrative Presiding Justice of the Court of Appeal, 4th Appellate District, Division 1. Counsel, welcome back, and you may proceed when ready.
Yes, Your Honor. Robert Gerstein for Petitioner Kurwa. Your Honors, we are here once again. This time, the question is whether the law of California can allow the one final judgment rule as articulated by this court in such cases as Morehart and Kurwa 1 to be used to deprive litigants of the right to appeal indefinitely in circumstances such as these. It is our contention that to do so would be completely inconsistent with the law regarding the right to appeal as it has been developed under the leadership of this court. This court has created a bulwark of protection for that right, which extends very broadly. The right to appeal cannot be abrogated by statute. Unless the statute is absolutely clear and every doubt is resolved in favor of the right to appeal. As to waiver as well, waivers must be clear and express, and all doubts are resolved against the existence of waiver. It is even the case that the right to appeal cannot be chilled in various ways because it is a fundamental protection of the ability to obtain a remedy when a right has been violated. So you can't have a chilling effect from even the dismissal of frivolous appeals, except in the most egregious circumstances.
So here,
yes.
Following this court's decision in the first round of litigation from our perspective, the trial court, when asked to rescind the stipulation that gave rise to the problem that kept the appeal from being perfected under the one final judgment rule, took the view that it didn't have the authority to rescind the stipulation to vacate the judgment it had earlier entered. Was it correct?
No, Your Honor, it was not. The trial court took the view that it had entered judgment and could do nothing further. But this court held in Kurwa 1 that there was no final appealable judgment. So the answer is absolutely not, Your Honor.
Would it suffice to take care of the problem we have here, just to make that clear? Remand to the case to the trial court with the additional clarification that because the judgment was not final and appealable, the court retains the power to continue to act and to enter a final judgment?
Well, Your Honor, in order to enter a final judgment under Kurwa 1, we would have to be also freed from the stipulation which establishes that there is a waiver of the statute of limitations, because this court said that under those circumstances, with a cause of action which has been dismissed without prejudice and a waiver, there can be no final judgment. So one of the things we are suggesting this court could do to resolve this kind of issue in this case and in future cases is to remand with the direction to vacate the supposed, in fact, not real judgment, and also the stipulation on which it is based. That would allow us to go forward. At that point, in fact, in our view, we would have a final judgment. There would be nothing that would stop it from being a final judgment.
And what would the basis for rescinding the stipulation be?
That it is based on mutual error of law. And that is clear from the decision of Kurwa 1. Kurwa 1 said, basically, that the parties and the trial court and the Court of Appeal were simply wrong in coming to the conclusion that you could have an appeal, an appealable judgment, under these circumstances.
So trial courts are often eager to get the opinion of a court of appeal on an issue they have before them without finally resolving the case. Having been a trial judge for many years, I'm aware of that. Is it your position that every trial court has inherent authority to resolve any cases where there's not a final judgment as where it was dismissed without prejudice?
I would say yes, Your Honor, if there is no final judgment and there is no legal bar to entering final judgment, as there is in this case, and this is our difficulty, of course, there is in this case because of the rule of Kurwa 1, that yes, once relieved of that, the court can enter final judgment.
Is there a wrinkle having to do with Mr. Kisslinger's cause of action in the cross-complaint for the defamation action against Mr. Kurwa? What's the status of that? I understand it's still outstanding.
Well, it is still outstanding, and that's the whole problem here, Your Honor. As counsel said in the briefing, the problem is the stipulation. The stipulation basically says that this is dismissed without prejudice, and that it can't be brought back unless and until there is an appeal and there's a reversal. We are then in a situation in which, unless Kisslinger is willing to leave behind this stipulation, to agree that the stipulation should be at an end, or to dismiss his cause of action with prejudice, no final judgment can be entered.
Or to litigate it, right?
Or to litigate it, absolutely. Yes. Now, the stipulation says they can't litigate it unless
right.
there
So
has
you
been...
undo the stipulation and return the
Undo
parties.
the stipulation and litigate it, absolutely. And we are perfectly willing to see that. What we want to see is that this case goes forward and we finally determine what justice requires in this case. The Court of Appeal said once what justice requires. but that was nullified by this court's decision that there was no appealable judgment. We'd like to get to that point again, and to get to that point in a manner that will allow that decision to stand. What we have now, in fact, instead, is a situation very like that described by the Court of Appeal in McDonald versus Superior Court, where you had a situation in which, as described by the Court of Appeal, the trial court interpreted sanction statutes as conferring upon it the unprecedented power to prohibit an appeal from its own judgment. But what we have here is a situation in which a prevailing party has the unprecedented power to prohibit an appeal from a judgment in his favor. That simply does not fit with the law of California with regard to the right to appeal. And that ability must be removed. And we have outlined the way in which that can be done, and in our colloquy just now, it became clear how that can be done. The one final judgment rule is about, this court said, having appeals at the appropriate time and no earlier, and not having piecemeal appeals. It is perverted if it is used to make it impossible for litigants to appeal entirely. If there are no further questions at this time, I will reserve the rest of my time.
Thank you, Mr. Gerstein.
Thank you, Your Honors.
Good morning. May it please the Court, Dale Goldfarb for Dr. Kisslinger and related entities. Counsel continues to overcomplicate what this case is about. It's about a plaintiff who went to trial, lost primarily at trial, and cut a deal to avoid future liability to bar my client from bringing his claim for defamation. He made that deal, his lawyer signed off, and the trial court entered an order and judgment based upon that voluntary agreement. You can waive appeals voluntarily. He argues you have to have it forever, not if you waive it. And he ignores the fundamental fact that we are here. And he is in the situation in which he is in because he agreed to be there. The trial court did push him.
My understanding of the stipulation was not that either party at the time contemplated that it would be a waiver of the right to appeal. I thought the very purpose of entering the stipulation was to permit an early appeal so that the two parties could figure out how to structure their remaining time before the trial court to dispose of the outstanding claims.
I was one of those counsel.
Okay.
And the other counsel has never signed a declaration saying what he was thinking. He's around, we've talked to him, but in all the years since, and through all their motions, they've never had a declaration from that lawyer who signed it and who agreed to it saying, I made a mistake, I meant this, I meant that. They've never had him say that, and you wonder why. Because he knew what he was doing. It was not a waiver of the appeal, Your Honor, you're correct, but it was a limitation.
So an appeal actually was filed, which ultimately gave rise to this court's decision in Kurwa 1. Was there ever an argument raised in the Court of Appeal or in this court that none of these questions about the one final judgment rule were at all relevant because the parties had agreed that they would waive appeal?
Absolutely. The argument was made in this court that the agreement that was made at the trial court did not permit this matter to go forward. It contemplated an appeal, but the Don Jose series of cases raised the issue whether he could get an appeal on the merits or not.
So does
His counsel made a decision to take a chance.
So does the mutual mistake rule apply to allow rescission of the parties' agreement here?
Well, the trial court didn't seem to think so, and it was raised in the trial court after this court's opinion. They filed a motion to have the court vacate it and the court looked at the evidence before it and decided not to. So if the rule applied, the factual finding of whether it should be done was decided by the trial court not to do it. Trial court denied a motion to vacate the stipulation. Trial court denied a motion to amend the complaint. The trial court denied a motion to set it for trial. All those decisions were made upon the papers, the evidence before the trial court, which is the court that should be making those decisions. So yes, those issues were all raised and all were decided adversely to the plaintiff. They appealed those post-judgment decisions, which are separately appealable, and the Court of Appeal ruled that those were the correct decisions. So it's not really correct to say he's never had a chance to have it reviewed. The facts and circumstances of the agreement that was made were reviewed by the trial court where they were made, and the trial court didn't seem to have any trouble with where it was. In fact, the trial court said, counsel, you're here because prior counsel made this agreement. Maybe it wasn't a good one, but it's the one that he made.
But the trial court said he didn't have jurisdiction to go forward with the case because it had been dismissed.
Well, there's two different things there. The trial court said he didn't think he could change the judgment because they'd gone to the Court of Appeal, he lost jurisdiction. So that, in that sense, he did say that.
But it was back before him.
It went back before him when it went back, and he said, I don't think I can change this judgment now because it's already a judgment and it's gone up on appeal. And I only have limited post-review jurisdiction.
The judgment wasn't affirmed on appeal. It was just the appeal was dismissed as being from a non-appealable order.
That brings up an interesting point that I think answers your question. There are judgments, and they use the word, there are final judgments. At some point, judgments become final, and they don't always get appealed. Most judgments become final without ever being appealed because they either decide not to appeal it, or they miss the time deadline to appeal it, or they can't afford to appeal it. Whatever reason, most judgments are just judgments. The time to appeal runs, and the judgment becomes final because it's no longer subject to appeal. This judgment here, there was a judgment entered. It says judgment. It was approved by counsel. Plaintiff's counsel approved the judgment. We approved the judgment. The court signed the judgment. That judgment was entered. They say, well, it's not a final judgment. It's just a judgment. But it was still a judgment.
So is your position here is affirm the CA on either grounds that Mr. Kurwa loses, and he's never had an appeal from the trial court ruling on the presence of the fiduciary duty. And the reason he never gets to appeal that from the trial court is because it's an implied waiver because he made the benefit of this bargain, which he lost.
Exactly. That's exactly correct.
But so the CA the first time around, before the case came to us, actually ruled for Dr. Kurwa on the merits.
On a 2-to-1 opinion, they did.
Right.
But we believe that was a wrong ruling, but that ruling is gone now.
Right. So
they did rule,
that's water under the bridge at this point.
They ruled that there were questions of fact and the motions in limine should not have been granted on the fiduciary duty issue because everything else was dismissed voluntarily by, there were 10 causes of action, I think. Plaintiff's counsel dismissed all but 2 of those voluntarily on the day of trial. All that were left was an accounting and the fiduciary duty, the individual fiduciary duty claim. The rest were gone. That's all we're left with.
Right, but as to
and
the fiduciary
the court ruled
claims,
there was a question of fact, or there was a question as to the admissibility of some evidence that would have gone to the fiduciary duty issue. The issue is whether a corporation, 2 corporate officers owed a fiduciary duty to each other. Well, it's quite clear they don't, but the Court of Appeal made an exception to that rule, and maybe there is. Send it back to the trial court. So that was the opinion which was eliminated by this court's petition grant.
right. So at this point, the only thing that's changed between that ruling and now is that this court, in the meantime, has made clear that that appeal was improper because there was no single final judgment from which Dr. Kurwa could yet appeal, correct?
No, 2 things have changed. One thing is that this court ruled you can't manipulate the judgment to make it appealable, as the court said. The second thing that they seem to think is significant is that Dr. Kurwa, who also dismissed his defamation without prejudice with the waiver, has now entered, or thinks he's entered, a new and different dismissal and made it with prejudice. He dismissed it before without prejudice. And after going through this appeal and all the motions and years and hundreds of thousands of dollars of litigation, he decides to take the form, check the box with prejudice, file it, and that changes everything, is what they say.
Do you have any case law that you rely on for implied waiver of right to appeal?
Excuse me, Your Honor?
Case law that you rely on for implied waiver of right to appeal? Because I've only ever seen express waivers of right to appeal, usually because you're getting a deal, and you then expressly waive the right to appeal.
No, we didn't. There was no express waiver of the right to appeal.
Do you have case law on implied waiver of the right to appeal?
We think there was a limitation on the right to appeal. And the limitation was what the law was at the time and whether or not he'd be successfully reversing
Whether it's a
it.
limitation or not, you're saying he has no right to appeal.
That's right. No further right.
It's a waiver of a right, or it's a forfeiture of the right.
Well, I'd say waiver is more accurate than forfeiture.
Okay.
He got some benefit for that, for having taken that, because my client's defamation claim is gone as well, which we think had a tremendous value. We gave up our right just like he gave up some of his.
Counsel, just to keep you focused on the Chief's question, so to the extent that what you are arguing for can be characterized as a kind of implied waiver, it was not explicit, that was not what was understood, but it's sort of implied.
Correct.
There isn't necessarily a case you can point to where that was understood to apply and to be legal.
Not that I'm aware of.
Okay, thank you. Appreciate that.
I don't know about not legal, but not recognized.
So what's your best case?
Right.
So what gets closest to this situation that you can point to?
Well, there are some cases that are cited. There's the City of Clovis case where they did a similar deal, but it was a more negotiated situation on some property rights, as I recall. And the Court of Appeal said, you can't appeal now for the same reasons we have here. But it said, if you go back, and we're sending you back to trial court, and they went back and they voluntarily resolved the rest of their case.
And if we look at this the way you'd like us to, if we analogize this to City of Clovis, for example, what concern should we have for the subjective understandings of the parties at the time the stipulation was entered into? Should we disregard that? Should we consider that to some degree, but not to another degree? How should we think about that?
It should be disregarded. I think
Why?
You have to presume the lawyers who made the deal at the time knew what they were doing. The fact that they didn't know the law or misinterpret the law or were trying to push it one way or the other shouldn't matter as long as both parties did what they did and they got benefit both ways. What they knew or didn't know shouldn't make any difference in this court.
And you've stated it very clearly, and that's what I was hoping to get. And just to follow up, how general should that principle be? Is that something we should presume about any arrangement that is made with the benefit of counsel, or in this particular context with respect to appeal rights? Give me a scope of how broad the principle is.
In a civil case with qualified counsel, it should be up to counsel to make the deal, and the chips fall where they may. And if the decision made by the counsel was bad, the remedy is for a malpractice case by litigating against his or her lawyer for giving bad advice and making a bad decision. Otherwise, it becomes difficult in the trial court level, as Your Honor mentioned, to have anything be final or anything to move the case forward, because every arrangement and every stipulation, every deal that's made along the way can always be re-questioned and set aside, and so you lose a tremendous amount of the finality of the whole civil litigation process, because years later you say, we made a deal. Oh, no, but we were confused about that deal. Let's go back and set it aside and try the case again. And that could happen as to every agreement and every stip and ever. So it shouldn't be a consideration. The remedy should be, you talked about the prior case, the remedy should be there's a lawyer who's supposed to know what he or she's doing. And if they don't, the remedy is against that lawyer for giving bad advice, which is what the remedy is now. In most malpractice cases, or in many malpractice cases, you could say, oh, my lawyer wasn't negligent, and if he was, there was just a mutual mistake. Let's undo it and go back.
But
that's not fair.
Position isn't, your position, the reason there's no final, the reason we're talking about the stipulated judgment, well, the stipulation was based on the understanding that this piecemeal order was a final judgment that could be appealed. But we know now, after Kurwa 1, that that's not a final appeal. So you're saying the attorneys made this bargain. Are you saying that, since you were the attorney of record, you knew when you made that bargain that that wasn't a final judgment? Or did you also think that was a final
We knew
judgment?
there was an argument as to whether or not it would be appealable because of the 3 or 4 cases that existed. They thought they'd be able to get it heard on the merits. And in fact, they did. So they were right.
Did you say that on the record so everyone knew they were entering into some
Not
shaky
on the record,
agreement?
no. The record was, we were outside negotiating. We were there at trial, and we talked outside and came back in. He dismissed everything. It wasn't all on the record thing. It was the way trials really are done when you're down in the trenches. You try to do a deal, you go outside, you talk, you go back and forth, you cut a deal, the court says, great, you're done, and you move on. You don't expect to come back 5 years later and say, oh, let's start over
I
again.
am aware of that process, but it would also seem to me, however, that as officers of the court, if you thought you were entering into an agreement that was otherwise void or otherwise shaky or otherwise unreliable, and parties' rights were involved, that someone would have a duty to say, oh, by the way, Your Honor, we're not sure that this is a great deal. We're not sure about the legality of this deal, but we're both entering into it. You're making Dr. Kurwa rely on this deal, but I wonder what your intent was, or your client's intent, or the other party's intent in making this deal. It seems like they're benefiting from a mistake.
Well, someone always benefits from a mistake in life, whatever they may be. When you run a red light, there's always a benefit if someone makes a mistake. The question here isn't
courts
that.
often exist to
Pardon?
correct mistakes.
Pardon?
Courts often exist to correct mistakes.
That's absolutely. Absolutely. But
You aren't suggesting so broadly that we're without authority to correct an error.
no, but as long as there's a remedy, the general principle, every wrong should have a remedy, the malpractice claim is a remedy that would put Dr. Kurwa where he would have been if he won his case. He does have a remedy. If we go the way they're going, my client suffers. My client has done nothing wrong other than reach a deal everybody agreed to. He has spent a ton of money and time, and he's being asked to say, go back, undo the deal that you did, all the money that's gone is gone, and start over. At the very least, it should be like a 473 motion, where the other side should have to pay back all the costs and expense that got him to that point because he participated in that process that got him there. Oops, I made a mistake under 473. Okay, you get relief, but pay him for their trouble. But they're saying, no, Dr. Kisslinger loses all the money, loses all the time, and doesn't even have his defamation claim yet. And it's much worse now because witnesses are gone. He's been prejudiced in these 7-8 years that have passed to put his case on because of, evidence is gone in 7-8 years. But I understand there's a remedy that might take that into account. To me, the remedy is you say, that was the deal. It was a bad deal. It was a mistaken deal, perhaps. Sue the lawyers. Do whatever you have to do. But don't open up the system to that happening again and again in every case. If I may, Your Honor, to go back to your question about is there an obligation to tell the trial court maybe it's a shaky opinion. But you're never obviously going to lie to the court or hide from the court. But I don't think every time trial lawyers make decisions at trial, they have to tell the trial court, we made this decision. It might be a good one. It might be a bad one. We're not really sure. There's a couple of cases, and we don't really know. But we're making the deal. Let's call the next witness and move on and have this case get over. That's the reality of how it works. Otherwise, you could never agree on anything.
No, but the reality is that trial judges know that if there are unresolved causes of action and they're entering into a judgment, it's not final until those unresolved causes of action are taken care of. Trial judges know that.
Well, there have been a lot of cases post, as he says in his brief, and as Mika says, there have been a lot of stipulations like this even after those cases were decided. So apparently, it's not as clear as we all think it is.
I said that at the very beginning. They're trying to be creative to get the courts of appeal to rule on something that's not final. I believe that's what happened here.
I think there was some creativity for that to happen, but it didn't happen because plaintiff's counsel was able. You have to remember, plaintiff's counsel convinced the Court of Appeal that it was appealable. They convinced the court it was appealable and got their opinion. So how wrong could the opinion have been? Was it a mistake of law? When in fact, they did get their appeal. So they were right. The deal made was right. They did get to appeal. Turned out this court undid that. So it wasn't really a mutual mistake of law. It was a close call that could have gone either way, which counsel can make a deal about. And it was so close that in the first instance, they were successful. In the second instance, we were successful. So that goes to show it was a close call and not an absolute black and white decision. And if it's a close call and you make a deal for economic and strategic reasons at trial, it should not be upset or set aside later on when one side has second thoughts. Had it been absolutely, you can't do it. But that wasn't, because they got one court of appeal to buy in, which shows it wasn't certainly totally crazy. And my point is, if we go the other way and create these exceptions that they're trying to create, what this court would be saying is, anytime you make an agreement that has some question to it, it can be revisited and have that case go back. And that would have every case would go back 2 and 3 times. That doesn't create efficiency. And that's what this case is about. Thank you.
Thank you, Mr. Goldfarb.
Well, Your Honors, counsel said, and he said repeatedly, we didn't have any declarations saying what the intention of the parties and the counsel were at the time. Well, the fact is we didn't really need it because we have the reporter's transcript of the hearing, at which, in fact, both counsel made it clear that they were going to, they intended to dismiss without prejudice their causes of action for defamation in order to allow the judgment to become final on the central issues in the case and to have an appeal. That was the whole point. And counsel at that time said that we have agreed to dismiss these causes of action and waive the statute so counsel can get a ruling, a definitive ruling. The purpose of this was to get a speedy appeal. Regrettably, from the point of view of the parties, that did not happen. This was a period, you'll note, that from the time of Don Jose's restaurant until the Court of Appeal decision in Kurwa 1, there were 4 published opinions which said, you know, you really can't do this. And yet, parties and trial judges kept doing it. They didn't seem to get the message. They didn't know about it. It was a very useful thing to do. It was efficient. It was effective. And anecdotally, I've talked to many trial lawyers who say, well, yes, of course you should be able to do that. And everybody thinks so at the trial level. It's just at the appellate level that somehow things are different. So it's not the case that there was anything like even an implied waiver of the right to appeal. The whole purpose of the exercise was to get a speedy appeal and leave these other relatively unimportant causes of action aside. Counsel said that his client will suffer if he can't finally bring this cause of action for defamation, and that he has suffered because it's been so long and he hasn't been able to do it. Well, the fact is he could have at any time joined us over these past years in getting rid of this stipulation and could then have tried his cause of action for defamation, and we would have been happy to see that happen. City of Clovis, counsel cited that case, and I would point out, and of course it's clear in the briefing, that in that case, while the court decided that there was no final appealable judgment, it sent the case back to the trial court with a direction to vacate the judgment and the stipulation on which it was based. Precisely the relief which we have been asking for for years now, and which we ask this court for, and which would resolve this matter for Dr. Kurwa and others in his circumstances. One of the justices of the Court of Appeal along this long road that we've gone here, bringing a couple of petitions for writs of mandate, said that the circumstance in which we find ourselves is Kafkaesque. Can't go this way, can't go that way. We are stuck here without a remedy and without an opportunity to obtain justice. Your honors can now, and we hope will, free us from this Kafkaesque dilemma. Thank you, your honors.
Thank you, Mr. Gerstein. Thank you, Mr. Goldfarb. Matter submitted. One moment.
I just talked to him yesterday. Go by her with the podium. I think he's probably on his way here as opposed to not here at the court because I was thinking yesterday. We're the same height, so this should be here at 10 o'clock. And usually pretty responsible people. Movement.
So how long is the class from USC visiting oral argument or San Francisco?
2 days.
This is your first day here? Okay. Have you watched the courts of appeal or the trial courts as well? Oh, very handy. Very good. Calling the matter of Patrick Lowell Jackson versus Superior Court of Riverside County, the People, Real Party, and Interest. And we welcome the Honorable William R. McGinnis, Administrative Presiding Justice, Court of Appeal, First Appellate District, Division 3. And counsel, you may proceed when ready.
Good morning. May it please the court. Laura Arnold on behalf of Patrick Lowell Jackson. Talk about icing the kicker, right? In 1972, the United States Supreme Court held in Jackson versus Indiana. Side note, when I say Jackson from this point forward, I'll be referring to that case. Okay. No person charged with a criminal offense and committed to a state hospital solely on account of his incapacity to proceed to trial may be so confined more than a reasonable period of time necessary to determine whether there is a substantial likelihood that he will recover that capacity in the foreseeable future. Unless such a showing of probable recovery is made within this period, defendant must either be released or recommitted under alternative commitment procedures. Mr. Jackson was held on a bail order on unadjudicated criminal charges for which he is presumed not guilty presumed innocent, for more than a year following the date that the maximum term of his 1370 commitment expired. He was not held on any other basis. I have never said that no statutory authority exists to confine a person who is the subject of a conservatorship proceeding on pending the outcome of the conservatorship. In fact, every single pleading filed in the trial court, the Court of Appeal, and in this court, I have reiterated that the LPSA authorizes temporary conservatorships of a person who is the subject of a pending conservatorship proceeding, whether under the LPSA or under Welfare and Institutions Code 6500, which is where Mr. Jackson ultimately ended up. There was no temporary conservatorship in place at the time that the court set the bail order on the criminal charges. There was no temporary conservatorship in place at the time that the trial court denied my motion to release Mr. Jackson from county jail. There was never a temporary conservatorship in place from the time that Mr. Jackson was ordered released in May of 2015 until today. There's never been one. The holding of Jackson and Davis was codified by 1370. Well, 1370 already existed, but it was amended after Davis. And the reason that it was amended was because prior to this amendment in California, a criminal defendant incompetent to stand trial could be indefinitely committed. That person, while presumed innocent on criminal charges,
couldn't be indefinitely committed, but there was a great deal of latitude in terms of what a reasonable time for evaluation might entail.
Prior to Davis, there was no determination by the legislature as to what a reasonable amount of time
Right.
entails.
Case law simply spoke in terms of a reasonable period of time, so the statute made clear a legislative determination about what should be reasonable.
Yes.
And your position is you don't get to stack those periods.
Correct. Well, that was my position. It's also the holding of Polk. It's aggregate on the charges. So, yes, that is my position. And I think the situation best illustrates itself if I were to look at it this way. In this case, the people had filed a complaint. Mr. Jackson was committed for the maximum amount of time allowed under the law. He was ordered released. They filed a superseding indictment charging the same crimes. Had they filed that superseding indictment before he reached the maximum term of his commitment, there's certainly no way that 1368 would have authorized a new competency determination while he was still under commitment on the same charges. There's no difference that there was a gap of less than 2 weeks between the time that he was ordered released and the time that he was rearrested. The outcome is the same. 1368 still did not authorize a new competency determination. Once Mr. Jackson reached the maximum term of his commitment, or there was a certification or a report from the hospital saying that he was not likely to attain competency in the foreseeable future, both of which happened in this case, his continued confinement solely on the basis of being an incompetent became unlawful. I think what's also...
Could I back up and ask you just step by step a little bit?
Yes.
I know your ultimate argument is that he was improperly detained on the basis of his incompetence. Do you object to his rearrest?
I never moved to dismiss the Murphy petition on the ground. Okay, I never moved to dismiss the indictment. I don't think that there's anything that makes the filing of the superseding indictment unlawful. And I can see situations where the filing of a superseding indictment would be perfectly appropriate for the purpose of obtaining a Murphy conservatorship. And that's the reason it couldn't be done prior to the expiration of the maximum term of commitment, because the people hadn't gotten that indictment. That's going to change January 1st with the amendment to the law that the people have brought to the court's attention with now a probable cause determination, which is going to be a new thing. We'll figure that out. I'm sure you'll be hearing about it. We'll figure out what that is, and that'll be the new, probably the new way of doing it, less burdensome.
You don't really dispute that there is authority to initiate the rearrest under 1387?
The rearrest I have a problem with. So I guess I do. I don't have a problem with the filing of the indictment. I have a problem with the rearrest 2 weeks later. Yes.
Why? Just explain that distinction.
Okay. I'm going back to what Justice Corrigan said about the aggregate. It's the same charges. These are the same charges, no matter how many case numbers you put to them charges, whether you dismiss and refile, whether you file a superseding indictment, whether you dismiss and refile and then file a superseding indictment and then dismiss and refile again and file another superseding indictment. It's the same charges.
The problem with your analysis is there's a whole separate body of law that deals with dismissing and refiling. And in that body of law, it is a separate case. There's no rule that says the two-dismissal rule, for example, recognizes that the second case, which is a refiling, may be based on the same charges. So I guess to reach the remedy you want and not permit a rearrest creates havoc down the line in other cases completely different from yours. What would be wrong with a rule that says, as you acknowledge, the DA can refile, it's a new case, the defendant is now before the court on a new criminal case, the counsel can immediately declare a doubt, then the system starts, the court inquires whether or not there's a reasonable time for him to regain his sanity. Finding, as here, would be, no, there isn't. So now they don't get to hold him in a criminal context anymore because of the way you analyze the application of the statute. And so that throws you back to LPS or a Murphy conservatorship. What's wrong with that?
So I'm speaking now to a procedural situation that didn't happen in this case, but I want to go there because that is sort of what your issue presented was, and so I think I should probably talk about that.
Okay.
Okay. I didn't know nearly as much about the competency scheme when I started this case as I do now. But now that I've read everything that has potentially to do with competency and conservatorships, I think I figured out what the legislature intended because they made it actually fairly clear, although 1370 is in some ways clear as mud. But going back to the constitutional underpinnings of the amendments to 1370 that gave a time period during which an incompetent can be confined, it seems to me that what was intended with this entire statutory scheme was as follows. A person cannot be made subject to criminal proceedings while incompetent, nor can he or she be confined for longer than the reasonable necessary amount of time. So what we have is a scheme that allows for periodic review, beginning at 90 days when the person is received by the treatment facility and is assessed. And the court and the people are kept, and defense counsel are kept apprised at all times of the person's progress and his achievement toward attaining competency. After that initial 90 days, every 6 months, there's periodic review. And in fact, 1370 requires a new competency determination after 18 months, which I have to tell you I've never actually seen happen. But it does require that. And then 90 days before the termination of the period of commitment, everyone's made aware that the clock is running and you've got 90 days. So if you want a Murphy, you need to get an indictment. If it's not at past prelim and you haven't had a probable cause finding, you have 90 days to get an indictment. Now, of course, there's nothing in the statute that says you have to wait till 90 days before the maximum term of commitment expires to get that indictment or soon to be probable cause determination. That can be done at any time during that 3-year period. But absolute drop dead date is 90 days before the expiration of the term of commitment. In fact, the court is required to refer to public guardian for a potential Murphy conservatorship evaluation. In this case, of course, there was no indictment, so he was not eligible for a Murphy. So that was the end of that. However, once a person is made the subject of a Murphy conservatorship, the law actually requires that when the conservator has reason to believe that the conservatee has attained competency to stand trial, that he notify the sheriff department, the district attorney's office, and the superior court. The court sets a hearing within 2 days, and the person at that time can be made subject to bail. So it all comes back to square one, and that's 1372B and also 5369 of the Welfare Institutions Code. I look at all of this, and then I say, okay, so there's these charges that are requisite felony charges for a Murphy conservatorship, and it's kind of clear that the legislature intended that folks who are subject to those charges. At some point, there'd be some sort of probable cause determination, and they go the Murphy route, and they remain on conservatorship unless and until they no longer meet criteria, or unless and until they attain competency, at which point we go back to the court under 1372. And then there are these other folks who are charged with misdemeanors, who are charged with felonies that are not do not qualify them for a Murphy conservatorship. And as to those people, they can be made the subject of an LPS conservatorship if they're gravely disabled, meaning they can't provide for their own basic human needs, food, clothing, shelter. But throughout the statutes, it keeps saying that these charges are subject to dismissal under 1385. And I think that what the legislature was saying with all of that, this legislature is never going to order the court to dismiss something under 1385 because that's kind of an oxymoron. You can't do that. It's the court that's discretionary, right? I think what the legislature is saying is if it's not serious enough for you to get a Murphy after 3 years of continued confinement, not including pre-confinement credits, then why are we still holding this case around? I mean,
well, that'd be great, except the legislature hasn't quite said that.
Well, subject to 1385 discretion, certainly said throughout both 1370 and 1370.1, does not say you have to dismiss, but it does say what are you holding on to the charges for. And you know what's
the interest of justice is a very broad arena. There may be any number of reasons why a trial court may find that the interest of justice really does. The victim could come forward and say, I don't want to prosecute this anymore. The trial court could take that into account as whether or not the interest of justice would dictate a different result. So I'm just quibbling with you a little because it seems to be a fairly slender read on which you're relying.
Well, I appreciate that, Your Honor, and I think, you know, I'm looking at, again, the maximum periods of confinement and the purposes of punishment. And on a misdemeanor, I'm looking at a situation
one of the purposes is punishment, but another purpose is public protection. So it would seem that if the prosecution is entitled to recharge, which you do not dispute.
Correct.
There should be some mechanism for bringing a person who may indeed be a danger to the public back before the court so that all of the due processes can begin anew so that we can figure out how best to address this particular individual in a way that honors his or her rights as well as protecting the community.
And for the person who is made a conservatee, that statutory mechanism does exist. It exists in 5369 and in 1372. For the person who is not, at the expiration of the term of commitment, the subject of a conservatorship, there is no statutory authorization. Now, I understand that the refiling statute exists, and I can touch upon that, although I did save a lot of time for rebuttal, but I can touch upon that. But Mr. Jackson was a person who was not the subject of a conservatorship when he was released under 1370. And so now, if the indictment's filed, I'm not saying that he has to be made the subject of a Murphy conservatorship while he's still serving his 1370 commitment. A person who's living free in the community can be made the subject of a Murphy conservatorship. There's nothing in the statute that says they have to be confined under 1370 at the time that the conservatorship petition is filed. So let's say that he's out in the community now, and he's not subject to any conservatorship, and he's rearrested on a new charge, a totally separate offense, and a felony offense, and we'll keep it in the same jurisdiction. And the district attorney says, and he's found incompetent on that case, okay? There's nothing to say that a Murphy can't be filed, whether it's a requisite.
Right, but the predicate for your hypothetical is we have to wait until there's a new offense. Right?
No, that's not the predicate. That's just something that might bring him back to the attention of the authorities.
It seems to me that we're dealing with a person who we are presuming to be incompetent, which means to be so compromised that they can't really understand the nature of the proceedings against them or assist in their defense, which is a fairly compromised circumstance. And if I'm understanding you correctly, you're saying, well, we just have to let them be out there, hope they'll come see the nice doctor on their own because we can't otherwise dictate their behavior, or we have to wait until they commit a new crime.
I apologize if that was the way my hypothetical came across.
It may have been that I just misunderstood.
Okay. The LPSA authorizes the commencement of conservatorship proceedings at any time.
But only if they cannot feed, clothe, otherwise take care of themselves, right?
No.
Which is a different kind of incapacity.
So under the LPSA, we're going to call them Murphy and LPS okay. So when I say the LPSA, yes, they can be, at any time if they're gravely disabled in the true sense of the word, conservatorship proceedings, LPS proceedings can be started. But there's nothing in the Murphy proceedings that says that there's some time period during which a Murphy petition has to be filed. I think the legislature wants it filed during the 1370 time so we don't have gaps during which time a dangerous person is free in the community. But if that happens, as it did in this case, and the person, I'm not saying my client's a dangerous, okay. If that happens as it did in this case and the person's ordered released, there's nothing in the statutes, there's nothing in the conservatorship Murphy statute that would prevent the people from seeking a Murphy conservatorship as to that person at a time in the future.
But he has to remain out of custody in your analysis.
Well, unless they do they request a temporary conservatorship and file the right papers at the same time, in which case, boom, he's right in. So they at all times they had the potential, and let's just go to really where this ended up. This is a 6500. My client is mentally retarded. And so at all times, from the time that he was arrested until the time that the right petition was finally filed in 2016, there was nothing that would have prevented the people from seeking to conservatize and confine Mr. Jackson in a treatment facility under 6500. And there was nothing that prohibited them from doing it under the Murphy statute. They kept him in county jail for an extra year, and that is not authorized. That's not authorized under the Murphy statute. That's not authorized under 6500, and I don't think it's authorized under Jackson and Davis and the principles underlying.
Can I sum up, because it's been a long time since I've done a Lanterman-Petrus Act?
Sure.
But I know the LPS is it can be no crime at all. It can be wandering the highway. Law enforcement will pick the person up and bring them to mental health, and they will begin the holds and begin the proceedings and begin the testing. And there's 3 or so criteria for an LPS. But for a Murphy, you do need to be tethered to a charge. And that's where you're saying you can file an indictment for the Murphy charge, but what you can't do is incarcerate any further because they've received their 3-year max. Then there's a whole other scheme of 6500, which is separate and different and apart from LPS, which is basically no crime, to Murphy with the crime tether because you can be returned to court. And I guess the overgirding principle of all this is if it's behind a 3-year 1368 proceeding or 1370 proceeding, 3 years is the maximum time of incarceration, period, end of story.
Well said, Your Honor. That is essentially exactly what I'm saying, yes. I'm going to reserve the rest of my time for rebuttal. Thank you. Unless there's any questions right now. No? Okay.
Good morning. May it please the Court. I'm Natalie Lowe on behalf of the people and real party in interest. Petitioner falsely assumes that whenever criminal proceedings are suspended, any refiling of any complaint or other legal document in a criminal proceeding necessarily constitutes a continuation of the previous criminal proceeding. But as Justice Corrigan pointed out, that absolutely ignores the entire body of case law and statutory authority interpreting Penal Code Section 1387. And in fact, petitioner's reliance on Quiros and Tatiano to support this principle is misplaced. Petitioner repeatedly asserts that Penal Code Section 1368 does not allow for relitigation of competency proceedings once the 3-year commitment is expired. Period, end of story. And Quiros and Tatiano do stand for that proposition when it's a continuing criminal proceeding. At the end of that 3-year period, and a petitioner like Mr. Jackson is returned to court, we cannot relitigate competency under the current state of the law at that time, unless, in its real party's position, we refile a complaint and the prior indictment and the prior proceeding is terminated within the meaning of 1387 and a new criminal proceeding is instituted.
I think, counsel, the ultimate objection is to his being held beyond that point. So what is the justification for his being held?
Well, I think petitioner's argument that Jackson versus Indiana stands for the fact that you can no longer be held past the 3-year statute for any purpose, it confounds the meaning of the word commitment within the meaning of 1370 with being confined generally. And I understand that is semantics, and it would not matter to a petitioner in Mr. Jackson's position. Custody is custody. But from a legal standpoint, there's no constitutional or statutory reason why he could not be rearrested on proceedings, just because it's the same factual offense. For example, a petitioner recognizes that had he committed a new offense, he could be rearrested.
Yeah, that's true. But here, after he was rearrested, a doubt was declared as to his competency, right? And at that point, where are we legally?
Legally, at that point, we are in 1368 and 1369 territory where we are substantively litigating petitioner's competency. And while he could not be committed, Real Party, I will absolutely submit he cannot be recommitted within the meaning of 1370 to be restored. My position is he would have to be evaluated as to whether or not he would be restored to competency at that time frame, and if not, then he's released. And at that point, the prosecution have exercised an election to suffer a proverbial bite at the apple, and if we elect to go forward and he is found incompetent again and will not be restored, we cannot proceed any further and he must be released.
So was he, I guess I'm confused. So was he held then after a doubt was declared as to his competency?
Yes.
For how long?
He was, I think he was finally placed in a 6500 petition in February of 2016, so about almost a year.
Almost a year, right? So what was the basis for holding him for almost a year?
There were a bunch of competing reasons. So in the initial indictment was filed in May of 2015, there was, although not an order for contemporary or temporary conservatorship, there was a petition for a Murphy conservatorship filed. That is in the exhibits that were transferred from the Court of Appeals. It's a different case number. It is RIP 1500-604 as opposed to the request for judicial notice forwarded by petitioner. There was...
But that's not this case. That's not the case in which he was held. The case in which he was rearrested, a doubt was declared as competency, he was then held almost a year. I guess I'm still stuck on the question, what is the legal basis for holding him?
He was being held on the new indictment, Your Honor's correct, but to determine his placement for the conservatorship, and or ultimately it ended up being a 6500 petition.
So what is the statutory basis that you think best fits that period?
I'm sorry, I don't...
What is the statutory basis for holding him that best fits that period of time during which he was being held?
I think it's fact-specific, and I think in this case, and I understand Your Honor's confusion, but in
it's not confusion, it's just a question of what your argument is.
Yes.
I'm confused plenty of times, but just I think not right now.
In this case, there were petitions for conservatorships ongoing. So the Real Party would submit that would suffice to hold him given the severity of the charges that he was facing. There's no statutory or constitutional authority otherwise. In fact, Jackson says subject to civil commitment proceedings. Jackson versus Indiana does not state that in order to be constitutionally confined, you have to have a conservatorship signed, sealed, delivered. You have to be in civil commitment proceedings. Those were instituted here. But I do think that you could confine a petitioner, such as Mr. Jackson, under the indictment to relitigate competency only. So only for the proceedings under 1368 and 1369. And at that point, if we lost and he was not found competent or not restored...
But during the time that the proceedings were playing out, your position is he could be held for...
Yes. Given the severity of the charges, yes. However, I do think under...
The severity of the charges point, just unpack that a little bit. So the argument pivots on how severe the charges are.
Yes, because I think that once he's, bail is assigned at the indictment, the arraignment, petitioner has an option to relitigate his custody status under 1388. There are a petition for writ of habeas corpus. Again, they could renew to dismiss under 1385. There are lots of procedural avenues available to a petitioner in Mr. Jackson's position that were not exercised here. So there could be ways to release confinement if
And is there, I mean, again, I keep coming back to the statutory question because there are several statutory schemes here. And so I want to just understand if there is a statute that authorizes what you just described, or if it's to be sort of interpreted from what? From background? Keep on going.
I think it is the only interpretation that is a logical conclusion based on the canons of statutory construction and the interplay of the two statutory schemes. I do not think there is a specific statute that authorizes this procedure. I agree with Your Honor on that point.
Appreciate that. That's very helpful and helps me at least understand the limits of your argument and helps me weigh it.
Can I ask a procedural question just to sort of envision this process? So the 3-year period terminates and Mr. Jackson is returned to court. Did the court at that point issue what its normal statement is before he went? 3 years prior, the trial court said, criminal proceedings suspended because of the civil commitment. 3 years passed, Mr. Jackson's returned to court. At that point, under 1368 in the scheme of 1370, criminal proceedings are vacated and the matter is otherwise dismissed unless there's an underlying reason or basis or statute to keep Mr. Jackson in custody, because by now he's delivered to the jail and he is either not getting medical treatment or mental health treatment. He is in the jail, and at that point, he's in this limbo place. Criminal proceedings are now vacated because they're over, and at that point for this Mr. Jackson, was there at that point a felony charge holding him in custody with the bail amount set?
When he was returned initially from court, no. I mean, from Patton State Hospital, no.
So when he was in the county jail,
correct,
returned, he had done his 3 years, he was in this limbo place. At that point, he was held for a year. At what point, so you're saying there is no statute that allowed him to be kept there. It's a interpretation of the scheme that permitted him to be there for that year.
Yes, I would correct on one point, though, Your Honor. He was ordered released, but let me back up. He was initially committed in March of 2012. I mean, the argument as to when his commitment period actually began based on 1370 and the interpretation and his placement date is negligible because it ends up being about a month difference. But when he's first placed and ordered committed in March of 2012, he's returned and actually in an LPS conservatorship beginning in April 2015.
But he may be, but I'm worried about his custody status. You can be an LPS out of custody at the local mental health facility. You can even be under 1368 review and be out of custody.
Yes.
And yet, notwithstanding that he didn't have felony charges or any charge pending, he was still not released from custody. Is that correct? He's never been released from custody.
No, he was ordered released from custody on May 18th of 2015, and then the indictment subsequently was filed on May 22nd. So there was a Monday on which it was filed, on May 18th, and then a few days later there was an indictment filed. He was ordered released, and I believe, I don't remember exactly where he was housed, but I want to say it was county jail. He was not released, and I believe he was ordered released to San Bernardino parole. Why that didn't happen, I can't say, but I know that the court took the appropriate measures and did order him released.
So there was a 3 or 4 day period, 3-day, 2-day period, short period of time, where the original filing concluded he was awaiting indictment and there were no charges pending and he was in custody.
Correct.
And the indictment then was filed, and I assume immediately counsel declared a doubt.
Correct.
And at that point, then your argument is that he can be held in terms of evaluating competency, but if he comes back incompetent, then those charges must be dismissed, or now we move to a Murphy conservatorship or 6500.
I do believe civil commitment procedures would still be an option, but the court would absolutely have the ability to dismiss under 1385. I don't think that that discretionary authority goes away.
So criminal charges are dismissed?
That is an option available to the court, absolutely. And in fact, it could have been available here. I understand that this is, Mr. Jackson proved to be a difficult fit. As petitioner points out, he was initially committed under 1370. And then there was some debate midway through the declaration of competency as to whether or not he should be evaluated under 1370.1 and evaluated by Inland Regional Center. And then they rejected him initially. And then fast forward to 2015, He is, again, declared under, a doubt is declared under 1370 and will not be restored. And it isn't until almost a year later that he's found to be the appropriate subject for a 6500. And I bring up these facts to show that competency is a fluid factual scenario, and it's unique to every individual. And if the people cannot relitigate substantively competency, then we're left with a 3-year statute of limitations on very serious cases, like the case involved here, when in reality there's no statutory or constitutional reason for that result to occur.
And the statutes you rely on in order to have held Mr. Jackson for after the 3-year period are what statutes?
To hold him, I'm presuming Your Honor is not speaking of the 3 days, or are you speaking just generally?
I was speaking after his 3 years ended. That's counsel's argument. After the 3 years ended, he couldn't be held. He couldn't be held in custody. And you say he can because of this convergence of different statutory interpretations, and I'm wondering what statutes you rely on for that.
Assuming, arguendo, we had filed an indictment at the end of the proceeding, at the end of the 3-year period, then the people would, real party's position is that 1368 and 1369, that statutory scheme, allows us to hold a petitioner in Mr. Jackson's position to litigate his competency based on bail, schedule, et cetera, and the severity of the charges would control. However, again, petitioner could have sought review of the bail, and the court would have had it in its authority to release Mr. Jackson OR, to lower his bail. There were other options available to him.
I hate to get picayune, but usually it's my recollection that when criminal proceedings are suspended and a civil commitment is, and civil proceedings are instituted, bail is exonerated. No?
That's not my understanding.
Bail set while the court was doing a competency evaluation?
Yes, in this case, yes. And in fact, he did. And in fact, at one point, bail was exonerated and he was remanded to court, and the bail was increased prior to the 2015 proceedings. It was not set at $1 million, that's for sure, but it was increased. But even if bail were exonerated while criminal proceedings were suspended, there's no reason why we couldn't confine them to litigate competency. How else are we supposed to ensure that public safety, how else are we supposed to ensure that the public is protected from somebody who is charged with very serious crimes like Mr. Jackson?
How about filing for a Murphy conservatorship before the 3 years elapses?
And that's an excellent point. However, there's really no incentive to do so when there is the statutory scheme built into 1370 that allows for review, and we're not sure if a defendant in Mr. Jackson's position is going to be restored to competency. We would have a superseding indictment.
You're 90 days out. He's been in for whatever 365 times minus 90 is. Why are you not on notice that it doesn't look like he's going to get better, and you are taking the position that he's still dangerous? So why not start a Murphy conservatorship? And I'm a little puzzled by the answer that there's no motivation to do so.
Well, here, in particular, there wasn't, because he was in an LPS. He was found unlikely to be restored to competency in September 2014. He was then subject to an LPS conservatorship, and the people had no reason to think that that would not be, he would not be conserved for the year period of an LPS. However, here, they found that he was not the proper subject of an LPS because he wasn't an actual resident of Riverside County. He was a San Bernardino County resident. So at that point, we were scrambling. And I don't say that to denigrate my office. I say
Aren't you supposed to scramble sooner?
Yes, but unfortunately, we are detrimentally relying on other agencies. We cannot initiate Murphy conservatorship proceedings independently. We need the blessing and evaluation of a public guardian entity in order to proceed. So even if we had the indictment, we wouldn't have necessarily had the evaluation in place. And while it may have made it easier, it doesn't necessarily change the fact that the prosecution can relitigate competency. I believe that they are two separate issues. The Murphy conservatorship civil commitment scheme is what is available to the prosecution when we are out of options, when there's no other way to litigate or hold somebody. But here, we filed an indictment to seek a Murphy and subsequently relitigated competency proceedings. Because, as you'll note in the facts, Mr. Jackson, and while this in all candor may have not been I don't know the exact intent of the prosecuting DA who appeared, but Mr. Jackson had been found competent in his San Bernardino proceedings earlier at 2 separate occasions to show the fluidity of his competency. So it wasn't in bad faith.
An LPS hold in San Bernardino?
I'm sorry?
On an LPS hold in San Bernardino?
No, he was prosecuted on another case in San Bernardino and was found competent when he entered his guilty plea. And then he was found incompetent after entering his plea and then found competent again and sentenced. So there was a lot of fluidity to Mr. Jackson's competency. It was not in bad faith or somehow an attempt to circumvent Mr. Jackson's freedom, as petitioner kind of alludes to. It was an attempt to get a Murphy conservatorship, the filing of indictment, and there was a good faith reason to think that his competency may be at issue. The last determination we had to show that he would not be restored was September 2014. Well, several months had passed, more than 6 months had passed between that time and when Mr. Jackson when the indictment was filed. So at that point, the people elected to refile the indictment and have it constitute a termination within the meaning of 1387 and go forward on the indictment. Petitioner did point to the legislative intent that it's supposed to be a bright line rule. But there really is no practical way to restore someone to competency if they are released. For example, if Mr. Jackson had been released and we wanted to relitigate his competency at a later date, we would have no mechanism subsequent to filing a new legal document, a new pleading, to go, I don't want to say arrest, but to go get him, to evaluate him. You cannot restore, under the current statutory scheme, to competency without a medical doctor's evaluation or a psychiatric evaluation. There's simply no way to achieve that or have someone submit to that against their will without having corresponding criminal charges and a subsequent competency litigation. There's simply no procedural mechanism to make that available.
I just want to make sure I'm clear on one small practical reality. You can't, or a Murphy conservatorship can be sought against someone who is out of custody. Is that right?
Yes, but practically speaking, it wouldn't be possible to get them to submit to the evaluation involuntarily. They would have to be evaluated by the public guardian psychologist, and absent a criminal proceeding, I'm assuming in this hypothetical that criminal proceedings had been dismissed and there simply was no criminal charges attached, then there would be no way to get the evaluation necessary to institute Murphy conservatorship proceedings. So say, for example, in your hypothetical that we release, and the case is dismissed pursuant to 1385, at that point, there's no mechanism unless we file an indictment and somehow get physical control over Mr. Jackson or somebody in that position's corpus to get an evaluation for Murphy conservatorship. There's no way to make them submit to it. We can't say, hey, we'd really like you to come down so we can conserve you against your will. So practically speaking, while it would be nice for them to let us know, I think I have a mental problem, I might hurt people, I don't think it's realistic.
Going back to your point about competency for a moment, I understand your point, and I do see it as a potential problem. In other words, that somebody who may or may not ultimately become competent, currently has been adjudicated to be incompetent, cannot be forced after the 3-year period, if we accept opposing counsel's argument, to submit to some evaluation. I guess the question is, even if one has sympathy for that argument, the statutory scheme arguably could also be read to recognize that, though that may be a problem, at the end of the day, a line has to be drawn. And I guess going back again to the question of the statutes, what do you think is the best statutory argument that the whole statutory scheme was sort of meant not to leave the problem that you're identifying of somebody who can't be forced to submit to a competency evaluation?
I think the best argument is that the presumption of competence is restored upon refiling criminal proceedings. And once that is restored under Penal Code Section 1369, the prosecution has an election to make. And if the prosecution elects to substantively litigate competency, then that is necessary a termination within the meaning of 1387. At that, the prosecution absolutely has the option to stipulate that a defendant or petitioner in Mr. Jackson's position is incompetent and will not be restored to competency. And at that point, it is a continuation of the prior proceedings because there's no new substantive litigation. I think that Paredes, and I know that's judicial authority, but Paredes and Martinez and Berardi and the judicial authority that's interpreting 1387 makes that quite clear, that when you substantively litigate like a 1538.5 motion or a preliminary hearing, you are taking another bite at the apple.
I see. So you're saying effectively, just to paraphrase, it would be awfully strange if we have this presumption built into 1387 that you're restored to competency if charges are refiled, but there's no way of forcing you to submit to an evaluation to reconcile that with the fact that we previously found this very same person not competent.
Correct. Exactly, Your Honor. And as I alluded to earlier, it is this interpretation of these two statutory schemes that yields the best public policy results. I mentioned earlier that to rule otherwise kind of leads down the road, as Justice Berniers noted in the dissent and the concurring opinion in Teitano, which is it would be a de facto statute of limitations on our most serious crimes. It would be a de facto statute of limitations even when confronted with new evidence that a defendant in Mr. Jackson's position was in fact competent. And the hypothetical I used in the briefing was as someone who had been adjudicated in a separate county or even in that same county as competent. Under petitioner's interpretation, the prosecution would be bound by the prior incompetency determination indefinitely. And there's simply no reason to conclude that must be the result, or that was legislative intent. And I don't know that the legislative intent is necessarily indicative if we're going back to the legislative intent in 1974, when 1370 was first enacted. In 1974, as I pointed out in the briefing, the prosecution could refile indefinitely. And so if the prosecution could relitigate competency potentially indefinitely, it would make a mockery of the 3-year limitation in 1370 and violate Jackson versus Indiana. However, in 1975, and then subsequently again in 1980, when limitations were, rightfully so, imposed on the prosecution's ability to refile criminal proceedings to avoid harassing a defendant, the interplay between these two statutes becomes clear. And while
but that brings us right back to the stacking question, does it not? So your position is what the legislature intended to do and what we should endorse as sound public policy is to say, okay, there's a limit. The legislature can make a 3-year limit, but because of the interplay of the statutes, we should reconcile them to give you not 3 years, but 6 years.
No, I would think Polk would still control. I do not believe, and I would completely concede, that a petitioner in Mr. Jackson's position could not be recommitted for restoration of competency.
But you're saying 3 years plus whatever time it takes to determine, if that's the case, that he is not competent.
Correct.
And that can take how long, though, as a practical matter?
Well, it took at least a year here, right?
Right.
And in fact, I don't know that his competency was ever finally litigated. He ended up being in the 6500 petition. But at the end of the day, there are procedural avenues in place to protect defendants in that situation, so it isn't an indefinite confinement.
But the problem is that, like happened here, if it's 3 years period plus whatever period of time in the new filing to determine competency, then the prosecutor and the county could drop the ball on their end after the 3 years, dither around to file an LPS or a Murphy or an indictment, and the person who pays the price for that waiting period is Mr. Jackson, who is basically not culpable during that period because he was incompetent and there's no finding, as far as anyone knows, that he's competent now, and he served his 3 years. So it's until, as been alluded to here, until competency is determined. In this case, it was never determined. 6,500 proceedings came into play because he has been determined to be developmentally disabled. So that 3 years plus whatever it takes, it's that period of time of whatever it takes to determine competency that seems to infringe on his liberty, because otherwise he's incarcerated for that period of time. And he has to wait on the bureaucracy getting the right conservatorship. That's how I'm hearing this anyway.
I think that as I mentioned earlier, there are two different, and I understand it will not matter to a petitioner in Mr. Jackson's position, but there are two different reasons legally for the confinement. One is the commitment to restore to competency, and that is a 3-year bright line rule. But there is no other statutory authority or constitutional authority that requires the release of a defendant who is subject to new criminal proceedings or the refiling of criminal proceedings. For example, if their competency wasn't an issue, it would not be a violation of the defendant's criminal rights to hold them longer to relitigate another substantive issue, such as a 1538.5 motion or another preliminary hearing. The prosecution has that ability to make that prudent election if the facts.
Right, but under that circumstance, the defendant has another line of defense by refusing to waive time. At the very least, he can limit his exposure to incarceration by saying, okay, if you want to do this again, that you get to, but I'm not waiving time, so you better hurry up. We don't have that avenue of protection available to a defendant like Mr. Jackson, do we?
No, but there are other procedural avenues available. Like a petition for writ of habeas corpus is still a procedural avenue available, a 1385 dismissal, relitigating OR status under 1388. All of those are available to a petitioner or a defendant in Mr. Jackson's position, that it would allow him to be out on his own recognizance while competency was determined, even if that were not in the best.
I would find it quite surprising, in light of these charges, for the district attorney not to take an adverse position on such a motion.
Yes, and I was speaking more generally that for the less serious crimes, for example, that may reach to the level of a Murphy conservatorship because
but here we're dealing with quite serious allegations.
Yes.
So what's a person like Mr. Jackson supposed to do? Come back and say, well, I know you don't have to let me out, but even though they're accusing me of fairly serious allegations against a juvenile victim, just let me out. What do you think the chances of that are?
Probably quite unlikely.
Right. I mean, and so that's quite a different circumstance from the I'm not waiving time and there's a bright line rule and you have to bring me to trial by this date, or you have to give me my prelim by this date.
Correct. And while
avenues of protection are not quite equal.
But there are still, and I understand Your Honor's position that it may not, there is no bright line rule, correct. But there are still protections available. And it would be up to the court and petitioner's counsel, as well as the prosecution, to presume that that was, or to ensure that that was expeditiously decided. For example, that there could be a jury trial that would happen very quickly under 1369. There would be, I mean, usually, speaking from experience, I cannot speak to all counties generally, but usually a 1368 evaluation takes about a month to return. And at that point, we either can elect to go forward on a jury trial or we can stipulate to the reports of the doctors. And at that point, a defendant is declared incompetent. If that happens, it would be no longer than a month or two. It would simply be as long as it takes to get an evaluation completed by an appropriate doctor selected by the court, have it returned to court, and at that point, the prosecution could elect.
Of course, whether or not a month or two is a significant period of time depends on which side of the bars you're standing on.
Absolutely. But it would not necessarily be an indefinite commitment, and it would not necessarily be the year-long that occurred here for extenuating reasons. There were confounding reasons that delayed or prolonged Mr. Jackson's commitment.
Thank you, Ms. Lowe.
Thank you.
In the existing statutory scheme, the legislature, I think, is clear. If you want to confine a criminal defendant incompetent to stand trial based on unadjudicated criminal charges beyond the maximum term of commitment, you need to get a Murphy. Or you need to get a Murphy. And I think that the DA is absolutely incentivized under existing law to begin that process as early as necessary, given the circumstance of the case. Some cases may be past information. in which case getting an indictment wouldn't be necessary and you could just start with the evaluation. Some are not, in which case an indictment or soon to be probable cause determination will need to be obtained. Both of those things can happen while the defendant is incompetent. But it needs to be done, and the onus is on the people to do that, and they didn't. And I think that I do appreciate the policy argument that where the people have dropped the ball, there should be something else there in the in some statute that would authorize them to rearrest, reincarcerate, and reconfine an individual believed to have committed a serious crime.
Can I ask you about the gap? So I understand you're saying in order to prevent this period of time where a petitioner like Mr. Jackson is in this limbo, 3 years behind him, but not looking to any formal hold, that the prosecutor must, in that 3-year period, within 90 days before expiration, file for a Murphy conservatorship within the last 90 days of Mr. Jackson's 3-year commitment period under 1368, 1370. But if the DA or the prosecutor fails to file that Murphy within the 90-day period, and Mr. Jackson is returned to jail and is sitting there where criminal proceedings have ended, but the prosecutor has not yet sought the indictment or not yet have an indictment, it could be seeking it, but doesn't have an indictment, what's to happen to Mr. Jackson under those circumstances?
He must be released. I mean, that's, and let me just say this. There is nothing in the law that says they have to wait till 90 days before the expiration of the term of commitment to seek an indictment, nor is there anything in the law that says they have to wait until the last day of the 3 years to get a temporary conservatorship. And let me give you this scenario that exists commonly in Riverside County. There are individuals who have pending murder charges from decades ago who are on conservatorship and have been on conservatorship for decades. They're under LPS conservatorships for whatever reason, but they're on conservatorship. And they did not remain confined for the maximum time permitted under 1370 because prior to 2011, we all thought that pre-confinement custody credits reduced the maximum term of commitment, okay? So prior to 2011, a bunch of folks got out before the 3 years should have been up had we known what we were doing at the time that we were calculating that. So that 3 years, that reasonable time has not expired. We haven't burnt it all. It's almost like probation in prison. We haven't burnt it all. There's some time left, okay? They're out. If the people want to reevaluate their competency, they simply ask the court to order under 1368 that the defendant be interviewed, be evaluated, that an alienist be evaluated, that the defendant be evaluated. That probably isn't legal because of 5369, which is since they're under conservatorship, there's actually a mechanism to get them there. But we don't really worry about it because we know that they have not maxed out under 1370, and that if they refused to comply with the evaluation, well, it doesn't matter. They don't have to comply with the evaluation. The alienist can do it with or without their cooperation. But because of that remaining time, there's still some, I hate to use the word, but jurisdiction there on that criminal case because it hasn't all been burnt. They haven't been confined for the statutory time. That's why I'm saying you don't wait until even the 90 days when you know that you've got serious charges and you don't have an arraignment on information yet. You can't. That's why I'm saying you don't rely on the public guardian to do an LPS on a person who you know qualifies for a Murphy. I get it. There are other resources there, and nobody wants to expend the resources or money if somebody else is going to do it. But the person who suffers at the end of the day is someone like Mr. Jackson, who ends up released thinking that he's going home to his mom, and then rearrested and kept in county jail with no statutory authorization whatsoever for a ridiculous amount of time. And it wasn't to assess whether he was competent to stand trial. That never even happened in that year.
But let me pick up on that, counsel. So what would be your response if that were the reason and if there were some effort made to assess competency that took some time? Would your position still be that there'd be no time for that and therefore it could not happen?
I would say there's no statutory authorization for that under 1368, notwithstanding the fact that 1387 isn't a bar to refiling.
Defendant could voluntarily submit to it, but there would be no authority to compel defendants. In other words, is the authority to compel the same thing as the authority to hold?
So let me speak to that. First, let me say that defendants quite frequently don't cooperate with 1368 evaluations because many times they're severely mentally ill.
Of course.
But alienists are very comfortable rendering an opinion without that cooperation based on, in this case, they've got 3 years of records at Patton State Hospital. So I think they could probably get there with the defendant cooperating. But what the language in Indiana, Jackson versus Indiana versus Jackson, I may have flipped it, the language speaks to confinement. The due process language speaks to confinement. It doesn't speak to commitment. And I get it that the 3 years is commitment, but at some point the confinement becomes unconstitutional on the criminal charges, no matter what case number those charges bear. Whether it's the initial case number or the case number assigned to a superseding indictment or the case number assigned to a new felony complaint after dismissal of the original one, it doesn't matter. You can't stack them. It is the same charges. The same due process principles apply. And after a reasonable time period, deemed 3 years by our legislature, the confinement becomes unlawful and unconstitutional. And without any statutory basis to reconfine the individual, to rearrest the individual, what are we doing? I get that we want to know if he's still incompetent, but he was just released without a determination of competency 2 weeks ago. I understand that 5 years ago, for 1 month in San Bernardino, the month it took to get a guilty plea rendered, he was apparently no longer incompetent, but then, of course, degenerated a month later because he was still mentally retarded. And then the 1 month it took to get him back to court to be sentenced and out, he was competent, but that's subject to appeal right now on IAC grounds. So what I'm saying is this. The reason that the statutory scheme exists is because it was the legislature's best effort at making sure that dangerous people can remain confined under some provision of law with due process other than the criminal charges beyond this 3-year period. And that other individuals who are not subject to that alternative commitment proceeding be released. And for 40 plus years, this court and appellate courts in California have had no trouble understanding the mandate of 1370 subdivision C. And I don't think it's correct that just because the people failed to get what they needed in time to do the thing that they needed to do, that we should ignore both the legislature and the Constitution. Okay, thank you.
Thank you, Ms. Arnold. Thank you, Ms. Lowe. Matters submitted. We stand in recess until our afternoon session.
Supreme Court of California oral argument calendar session will commence soon. Please stay tuned. Supreme Court of California oral argument calendar session will commence soon. Please stay tuned. Supreme Court of California oral argument calendar session will commence soon. Please stay tuned. Supreme Court of California oral argument calendar session will commence soon. Please stay tuned. Supreme Court of California oral argument calendar session will commence soon. Please stay tuned. Supreme Court of California oral argument calendar session will commence soon. Please stay tuned. Supreme Court of California oral argument calendar session will commence soon. Please stay tuned.